May I please, Your Lordship. Lordship, item number 44, only one bail matter, Lordship. As per the instruction of learned PPCD is not available, Lordship.
My lord, we have not received the case diary, Lordship. May I pay for 1 week time, Lordship?
All right, item 44, you write, Mr. So-and-so learned counsel is present for the petitioner. Mr. R. Borua, learned APP submits that the case diary as called for by this court is yet to be received in this case. As such, Mr. Borua seeks posting of this matter again after a week,
My lord.
list accordingly. Prayer allowed, list.
Lordship, interim is there, Lordship.
Interim order passed earlier to continue till then.
Much obliged, Lordship.
May it please your lordship. I have a small prayer for withdrawal of a case on Monday. Highly obliged.
May I please your lordship? I beg to mention item number 35 with due consent, lordship. 35, lordship may kindly adjourn the matter for 2 weeks, lordship.
Miss A. Bora, Miss
D.
D.
Bora.
Bora, learned standing counsel, Health and Family Welfare Department 6 adjournment in this case for 2 weeks. Since the prayer is made with the consent of the other side, same stands allowed. Please this case accordingly. Yes.
Obliged.
May I please, your lordship? My lord, I beg to mention item number 48 along with supplementary list item number 57, my lord. My lord, kindly adjourn the matter for 1 week.
48,
my lord.
57 on the prayer of learned counsel for the petitioner, these matters stand adjourned for 3 weeks. Yes.
My lord, kindly 1 week, my lord.
No, 2 weeks, 2 weeks.
Lordship, I beg to mention item number 47 of today's list, my lords. Lordship, I have informed the other side, my lords. Lordship, I seek an adjournment for 3 weeks to comply with the court's order, my lords.
With the consent of learned counsel for the opposite party, Mr. A.H. Earlier, learned SC Finance.
No, Lordship, I am appealing for, it's a contempt matter. I am appealing for respondent number 3,
Mr.
health.
A.H. Earlier, learned counsel appearing for the respondent number 6. 6 posting of this matter again after 3 weeks so as to enable his client to comply with the court's
Lordship.
order. Prayer allowed, list this case again after 3 weeks.
Obliged, Lordship.
May it please your lordship, with your consent of the other side, item number 55 may be adjourned for 4 weeks.
Item number?
55. May be adjourned for 4 weeks.
Hmm.
We'll file an affidavit in reply to the affidavit in opposition.
Miss, your name, please?
Ankita Das, A Das.
Miss A. Das, learned counsel appearing for the petitioner submits that 3 weeks time be granted to file rejoinder responding to the affidavit filed by the respondents.
My
Since
lord, interim order dated
Since the prayer is not
3/5/2000.
opposed, same stands allowed. List this case again after 4 weeks. Interim order passed earlier to continue till then. Yes.
Lordship, I beg to mention item number 16, Lordship. Mr. K. N. Chaudhary, senior advocate, appears for the other side. I've taken his consent, Lordship. If it is not inconvenient, can it be taken up on Wednesday, Lordship?
Item number
16, Lordship.
16.
16, Lordship.
On the prayer of Mr. R.K.D. Chaudhary, learned DSG appearing for the respondents made with the consent of the other side. Admission hearing of this matter stands adjourned for 2 weeks. List accordingly.
The date may be fixed. I am for a review.
After 2 weeks. After 2 weeks. 2 weeks as a fixed item. Yes. Yes.
My lord, item 22, my lord. I need to go through some provision of amendment in the constitution order on 27th amendment. Can it be taken after a week or so?
As paid for by Mr. R.P. Sharma, learned senior counsel appearing for the petitioner, this matter stands adjourned for a week. List again for motion after a week. List again, 1 week adjournment I am not granting.
2 weeks?
Adjournment 2 weeks, yes. 2 weeks so as to enable him to examine certain recent amendments made to the relevant law. Prayer allowed. Let this matter be listed for admission again after 2 weeks. Yes.
May I please, your lordship? Lordship, I pray for listing of 2 petitions regarding non-payment of pension. It may be taken up, lordship.
You are for whom?
I am for the petitioner, lordship. PHC department. On the opposite.
All right, 2nd week of June. Put it.
May it please your lordship, I beg to mention WPC number 3880 of 2022 for listing lordship. Any convenient date?
2nd week of June.
Much obliged.
In this case, we filed the affidavit yesterday, Lordship. I'm not sure whether it is in the record.
No, it is not in the record.
We have extra copy also with us.
Just one minute. Have you received the affidavit?
Yes, my lord. Just now, my lord.
Would you like to file any rejoinder?
My lord, actually, what happened, my lord, at this stage, my lord, I have no instruction regarding this, my lord.
Then you seek instruction.
Let the
We'll have
Wednesday,
it
my lord.
next week,
Wednesday, my lord.
Friday, next Friday.
Next Friday, my lord. Prior to that, my lord, appointment will be made, my lord. We have
All right,
on
Mr.
Wednesday.
D. Bora, learned counsel is.
Borua, Lordship.
Borua, learned counsel for the petitioner is present for the, is present, full stop. Mr. D. Saikal, learned Advocate General Assam, assisted by Mr. B. Chaudhary, has appeared and submits that yesterday. An affidavit has been filed in this matter on behalf of the department. Mr. Borua seeks 3 days time to obtain instruction on the affidavit. In view of the above and on the prayer of learned counsel for the petitioner, this matter is directed to be listed again for motion on 24/5/2023 by tagging the affidavit filed by the department.
Deeply.
Obviously.
Would it be on Tuesday, Lordship? Would it be on Tuesday?
Tuesday.
Because Wednesday morning I have to leave. I will not be available there after that week
Always.
All right.
on Wednesday,
Tuesday.
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 Lordship. Highly obliged, Lordship.
Obviously.
May I please, your Lordship. Lordship, this matter pertains to compassionate appointment, Lordship.
Mhm.
The order of the
What is the case?
Lordship. The order of the petition died on 27/6/2014. Lordship.
We'll dispose it of. Let the SLC take a decision.
And may I please, Lordship, kindly come to page 16. This is the DLC minus, Lordship.
Yes.
And relevant portion is on page 18. Here it
On
is
page 15.
18. It was not considered. His case was, petitioner's case was not considered.
Why?
Here, after examination of the applications and the economic conditions of the applicants, the committee decided to recommend the name of Sri Ranjit Borua, son of so-and-so, Sri Nitu Borgohai, son of so-and-so, for the post of grade 3, and Srimoti Kavita Payong, daughter of so-and-so, for against the vacant post of grade 3, considering economic condition.
Yes,
And
but what has
others are-
happened to his application?
Others are rejected.
Where is it written?
Ground does not make any.
Then he needs to know.
Yes.
He has heard Mr.
Lordship.
Counsel and counsel for the petitioner. Also heard Mrs. Borua, learned Government Advocate Assam, appearing for the respond numbers 2 and 3, and Miss D.S. Yogi, learned Nyog, learned SC Irrigation Department, appearing for respond numbers 1 and 4. First up, the father of the petitioner died on 27/6/2014 while serving as a pressure pump operator under the irrigation department of the Dhemadi division. Full stop. After his death, the petitioner submitted an application in the month of July 2014 seeking appointment on compassionate ground, and his application was also duly forwarded by the DLC of Dhemadi. Full stop. The grievance of the petitioner is that the SLC has neither considered his application nor taken a decision on the same till today. Hence this writ petition. First of all, by inviting the attention of this court to the next paragraph, to the resolution of the DLC held on 4/6/2015. Where do you say your name was recommended?
Lordship, not recommended, Lordship, neither rejected, not rejected, Lord.
DLC not recommended, but
It is deal.
on the basis of economic conditions, petition.
But his application has neither been considered nor rejected by the DLC till today. Hence this writ petition. Stop. By referring to the minutes of the DLC meeting held on DLC district level committee held on 4/6/2015, Ms. Borua, learned government advocate, submits that names of some of the applicants were forwarded by the DLC by taking note of their economic conditions. Full stop. However, Ms. Borua has admitted that there is no mention as regards the application submitted by the petitioner in the minutes of the meeting dated 4/6/2015. Full stop. Since the petitioner had submitted an application seeking appointment on compassionate ground, the same deserved proper consideration, and the outcome thereof ought to have been informed to the petitioner, which has not been done in this case. Full stop. By mere reading of the minutes of the DLC, it is not clear as to whether the application of the petitioner had been rejected or the same was kept pending for future consideration. Full stop. In view of the above, and as agreed to by learned counsel for both the sides, this writ petition is being disposed of at the stage of motion hearing with a direction upon the DLC to take a conscious decision on the application submitted by the petitioner in the light of the office memorandums governing the subject on the date of submission of the submission of the application, and thereafter communicate the outcome of the process in writing to the petitioner. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 6 months from the date of receipt of a certified copy of this order. Writ petition stands before the.
Deeply obliged, Lordship.
I have been instructed to pray for 10 days time, Lord. It is at the final stage. Lord.
For the enquiry office, I think, but you should not appear.
No, on merit.
My lord, this is only a simple. I have been, your lordships kindly see the situation of this.
Just 1 minute. Mr.
Lordship.
So we'll dispose it of within 2 weeks. Let the LR dispose of the.
Lord,
That's fine.
Heard Mr. D. Das, learned senior counsel, assisted by Mr. H. Raymond, learned counsel appearing for the writ petitioner. Also heard Mr. D. Nath, learned senior government advocate Assam, appearing for the respondents. Full stop. The petitioner was
Junior administrative assistant, my lord.
was or is he still working? Has
No,
he
no,
been-
he is out, my lord. He
Huh?
was.
Okay.
Compulsory.
Was
was
working as a
compulsory.
junior administrative
Assistant.
assistant in the office of the government advocate,
Senior
senior
government.
government advocate Assam. By the order dated
It's 3/4/2021. He was,
3/4/2021,
there was the impugn order which was.
penalty of compulsory retirement from service was imposed upon the petitioner on conclusion of a departmental proceeding drawn up against him. Full stop. Drawn up against him. The petitioner had preferred an appeal against the order of penalty dated 3/4/2020. But no, full stop, 3/4/2020, before the appellate authority, who is the legal remembrancer of the state of Assam. Full stop. Although the appeal was filed way back on 25/5/2021, the grievance of the petitioner is that no action has been taken in the matter till today. Hence this writ petition. Full stop. Next para. In terms of the order dated 12/5/2023, Mr. Nath has obtained instruction and submits that necessary steps for disposal of the appeal would be taken within 2 weeks from today. Full stop. In view of the above, and as agreed to by learned counsel for both the sides, this writ petition is being disposed of with a direction that the appeal preferred by the petitioner be disposed of with a reasoned order as expeditiously as possible, but not later than 3 weeks from today. Mr. A certified copy, a copy of this order be furnished to Mr. Nath, learned additional senior government advocate for necessary compliance. With the above observation, the writ petition stands disposed of.
Deeply opposed.
May I please, your lordship? Matter is related to compulsory appointment.
3 years service not left.
Yes, your lordship, but
These matters have to be remanded back.
Yes, Lordship.
Huh?
We have make appeal but not listed yet.
Why it will not be listed? You are not trying to get it listed.
Yes, Lordship.
We have to follow up process of law. You file appeal, you don't make a mention, don't get it listed. What option we have left? We have to ask the DLC to consider. Had Mr.
K. Kolita.
K. Kolita, learned counsel appearing for the petitioner. Also heard Ms. S. Borua, learned government advocate Assam, appearing for the respondent numbers 2. Respondent number 2, Mr. R. Gogoi, learned SC PHE has appeared for respondent numbers 1 and 3 to 5.
1, 3, 4, and 5.
1 and 3 to 5. The petitioner had submitted an application seeking appointment on compassionate ground after the demise of her husband.
Yeah.
Who died?
Father, lordship.
After the demise of her father. Who was serving under the Public Health Engineering Department in the Boko subdivision. Demise of her father on 6/3/2010 under the Public Health Engineering Division for under the Public Health Engineering, Boko subdivision. Full stop. The application of the petitioner was rejected on 12/9/2022 on the ground that her father did not have more than 3 years of service left at his credit on the date of his death. Full stop. The aforesaid stand has apparently been taken by the DLC by relying upon clause 1 of the OM dated.
Yes. Yes.
1st of June
June
2015. 1st of June 2015.
1/6/2015, wherein it has been laid down that the deceased employee must have at least 3 years of service left to his credit for the application for compassionate appointment filed by his heirs to be considered. First of, however, the fact remains that by the judgment and order dated, what is the date? 30th of January 2023, passed by the learned single judge. You all are not prepared with anything. You come for a picnic, it seems. Nobody knows anything. Huh?
31/2023.
31/2023.
Passed in WC number 1646 Bhaskar.
The learned single judge has set aside clause 1 of the OM dated 1/6/2015 by holding the same as unconstitutional. Full stop. If that be so, this matter would obviously call for reconsideration. Now, the application filed by the petitioner would obviously call for reconsideration by the DLC. Ms. Borua submits that although the state has preferred an appeal before the division bench against the judgment and order dated 30/1/2023, yet the appeal has neither been listed nor is there any interim order passed by the division bench suspending the operation of the judgment and order dated 30/1/2023 passed by the learned single judge. Situated thus, this court is left with no option but to set aside the resolution of the DLC Kamrup Amengao dated 12/9/2022 over the petitioner and remand the matter back to the DLC for fresh consideration of the application in the light of the law, in the light of the existing law, in the light of the law prevailing at this point of time. First of ordered accordingly, the consideration as directed by this court be made as expeditiously as possible, but not later than 6 months from the date of receipt of a certified copy of this order. Writ petition stands disposed. Right, I leave it.
Lordship, can it take the matter for some time?
What is the matter?
Lordship, this matter is.
My lord may kindly dismiss this petition, nothing. The father died in the year 1998 and he has applied in the year 2023. The case is the petitioner is dead, their steps brother is appointed by the government. They may approach the appropriate forum, whether he is a step brother or not, you are not aware.
Why you wanted to pass over?
So, because my senior my senior will argue this matter.
Who is your senior?
Mr. Isdas.
Call him. 15 minutes later, we'll take up. There is an order passed by this court 3-4 days back. Delayed application 19 years later.
No, sir, I will seek money.
Can you take out that order?
Man.
Some PR media or somebody was there. Call him.
Item 6.
Please, your lordship. This is relating to selection and appointment, your lordship. Your lordship, petitioner challenge the impugn order page 60, your lordship.
Yes, what is your grievance? Where is the select list?
Select list, your lordship will find page 26, your lordship. Four column,
Hmm.
last right hand side.
This is the
His roll
select
number
list of.
is, his
select
roll
list of-
number is 7, your
1 minute, select list of 2005.
my lord.
No appointment can be made on the basis of that select list. This is 2023. You want a select list of 2005 to be now
My lord.
operated.
But other persons were appointed. your
Maybe,
lordship.
but now it cannot be.
Only my appointment was not made, my lord.
Where is the earlier order of the court?
Earlier order, several orders, your lordship will
Hmm.
find, they have page 27, your lordship. 20, page 27, 28, your lordship.
Mr. Chaudhary, the fact remains that no appointment can be made on the basis of a select list of 2005. Even if you have a good ground, bad ground, that cannot be made.
No,
You
my
ought
lord.
to have got an interim order then, otherwise the list has expired. After more than 17 years, can the court issue a direction to appoint your client on the basis of a select list of 2005?
Definitely, my lord.
All right, you
because-
make your argument. I'll pass the order.
Well, let me 1 week time, I shall prepare for the argument, 1 week time.
All right, on the prayer of Mr. Aram Chaudhary, learned counsel for the petitioner, this matter stands passed over for the day. Register to list this case again for motion in the next week. Mrs. Burwa, learned government advocate Assam is present on behalf of the state. You
All
also,
respond-
you
all
also obtain
respond-
instruction, huh?
All respondents are input.
All respondents, yes.
Mas- May I please, my lord, in this case, the petitioner, he has been penalized by my lord without asserting the facts, my lord. He was ordered of a jail of Guwahati Central Jail. And the duty, he along with other persons were also there. But action was not taken against other persons without ascertaining the fact of actual time of escape. One detainee was escaped from the jail. There were several persons on duty. But in the inquiry, without ascertaining the fact of
So
actual.
you are challenging the order of penalty dated 23/5/2022.
Yes, my lord.
Will issue notice at this stage. Heard Mr. P.K. Goswami, learned counsel appearing to the petitioner, being entirely aggrieved by the order of penalty dated 23/5/2022, imposing the punishment of withholding one increment and also transferring the petitioner from Guwahati to Karimganj. This writ petition has been filed. Mr. Goswami submits that the impugned order is highly arbitrary and dehones the process of law. Mr. S.S. Roy, learned government advocate Assam, prays for 2 weeks time, 4 weeks time to obtain instruction. Issue notice returnable in 4 weeks.
All this.
Since Mr. Roy has appeared and accepted notice for all
My
the
lord, I
respondents.
have a small prayer, my lord, in respect of interim, my lord. May I pray for a notice in respect of recalling the transfer order?
Notice on interim may default.
Yes,
No formal notice is required to be sent in this case. Extra copies of the petition will be furnished. We will learn departmental counsel, requisite in number, so as to enable him to obtain instruction. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date.
Yes, senior counsel, you can arise in code number 1. My password the matter for.
Yes, but I'll call up again before the motion is over. After that, no more password. Yes.
Okay.
You give it to. I will also need one copy of this.
Yeah, we have selected select list ballot dated 3/1/2023 ballot, which is a base ballot 36 ballot. By
Page 36.
36. Serial number 3, my lord. Bakbor under search number 10, my lord. The private respondent has been selected as the Gao Pradhan, my lord. Despite of the fact that he is underage, my lord.
Huh? Sorry.
He has not attained the age of 30 years, my lord. As on the private respondent, my lord. As on 2/9/2020.
File appeal.
It has been decided by this.
As per 62C, appeal has to be filed within 60 days from the publishing of the select list. This select list was published 3/1/2022. Already 60 days elapsed last date.
No, but we can always direct the delay to the
No,
content.
within time frame, within 60 days. Yes. That was. Earlier
Then we'll
cases,
say it and admit the writ petition.
That's it.
Then we'll have to decide this matter.
Director to file appeal. Director.
He cannot be left remediless.
That's
What do you want to tell me? Appeal or writ petition?
it. May file appeal. That's it. Within.
Prefer an appeal
Division.
by explaining the delay.
Division commissioner to file appeal.
By explaining the delay.
Already, my lord, the page number 29, my lord, the honorable.
No, we will not entertain this writ petition.
Yes, sir.
Similar writ petitions have been sent back to
Yes,
the,
my lord, the division bench blood has decided the matter, my lord.
decided the matter what?
Is underage, my lord.
All right, the
No, yes,
divisional
madam.
commissioner
Yes,
will
madam.
pass an order.
Not it.
Commissioner.
All right, heard Mr.
Yes,
As Islam learned counsel for the petitioner, also heard Mr. S. Dr. Learned standing counsel, Revenue Department, Assam, appearing for the respondent number 1, and Mr. S.S. Roy, learned government advocate, Assam, for respondent numbers 2 and 3. First up. The writ petitioner herein had participated in the selection process for recruitment of Gao Pradhans. First up. On conclusion of the selection process by notification dated 3/1/2020, the Respondent number 2 had published the list of successful candidates wherein the name of the respondent number 4 figures as the successful candidate in respect of, where is respondent number 4? In respect of Bagbor Moja.
Yes, my lord.
of
Serial number
charge
3, my
num-
lord.
In respect of charge number 10
Yes.
of Bagbor Moja in the district of
Barpeta.
Borpeta, full stop. Assailing the selection of the respondent number 4 on the ground that he did not meet the eligibility norms in terms of age and hence was not qualified to be appointed and hence is not qualified to be appointed as a Gau Pradhan, the instant writ petition has been filed. Full stop. Mr. Islam submits that the age of the petitioner on the date of application was less than 30 years.
The private respondent.
Respondent number
Private-
4, my lord. Private. respondent.
Respondent number 4 was less than
30 years.
30 years, and therefore he was not eligible to participate in the recruitment process. Yes, full stop. The issue raised in the writ petition would require factual verification, which may not be permissible in a writ petition. Full stop. At this stage, the issue raised in the writ petition would require the court to go into disputed questions of facts which may not be permissible in a writ petition. At this stage, Mr. Datta submits that although the select list or the petitioner was, although the select list, although the list of selected candidates was notified on 3/1/2023, that is more than 60 days back, yet he would have no objection if the petitioner is directed to approach the jurisdictional divisional commissioner by preferring an appeal under section 162(c) of the executive instruction framed under the Assam Land and Revenue Regulation with an application for condonation of delay. Full stop. Similar is the stand of Mr. Roy, Learned Government Advocate, Assam. Full stop. In view of the above, then we write, Mr. Islam also submits that his client would be ready to prefer an appeal, but some interim order of protection be passed by this court. In view of the above, and as agreed to by learned counsel for the parties, his writ petition is being disposed of at the stage of motion hearing by granting a week's time to the petitioner to prefer a statutory appeal before the jurisdictional divisional commissioner. If such an appeal is filed within 7 days from today, along with an
Within 15 days,
application.
my lord.
Huh?
Within 15 days. my
No,
lord,
no,
please.
no, within 7 days from today, along with an application for condonation of delay by enclosing a certified copy of this order, along with an order application for condonation of delay, condonation of delay. The same be considered on merit and appropriate order be passed therein. Full stop. As an interim measure, it is hereby provided that if no order of appointment has already been issued in favor of respondent number 4, the same shall not be done without properly verifying the age of the petitioner on the date of submission of the application. Writ petition stands disposed of.
Of
All your question.
162C.
Huh?
162C.
May it please, your lordship. My lord, the case of the petitioner is this, my lord, that in 1991, he was appointed as a receptionist in Assam Tourism Department as an ex-cadre post, my lord. For long 26 years, my lord, he was being made to serve in an ex-cadre post without giving him any opportunity of promotion or career advancement. Subsequently, my lord, when he find no opportunity, no relief, he was compelled to approach this honorable court, and this honorable court on 2015 directed the respondent authorities to enter up the post of receptionist and give him due promotion. within the period of 6 months by amending the rule. Surprisingly, the respondent authorities took 2 years, my lord, for amending the rules. So in 2017, my lord, I was being promoted to my next promotional post, that is ATIO. Thereafter, my lord, I approached this honorable court again on the ground that I may be granted an notional promotion because I was having all qualification from the year 2005. My lord, so thereafter, my lord, this honorable court in 2021 had directed the respondent authorities to consider my case as because I have completed 5 years of service as an ATIO and the long period of service. Thereafter, my lord, what had happened? He, as per the rule, if my lord can, 2
Yes,
minutes
yes,
more, my
you
lord.
go ahead, you go
Yes,
ahead.
my lord. So, while disposing my second round of my writ appeal, my lord, which your honor will find at page number 57, my lord,
59.
44, my lord. But I'll take you the paragraphs, my lord. So what had happened on that time, my lord? The learned divisional bench, the honorable divisional bench has stated, directed them rather that consider my case as per the rules. Now, as per rules, my lord, I will be eligible for promotion from 1st of January 2023. They ought to have constituted the DPC after I become eligible. What they have done, rather, they constituted the DPC on 8th of August 2022, rejected my case, and accordingly an impugn order was passed. Impugn order is in the page number 59. My lord, for a moment, let me just show you 2 paragraphs, my lord, if my lord permit, my lord. At page number 35, my lord, it will give in an idea of what had happened. Para number 2, my lord, that is my first litigation, my first round of litigation. Appellants are working as a receptionist in tourism department of the state of Assam. There are 14 persons working as a receptionist. I was one of them, my lord. In the entire state, the posts were created in ex parte, ex cadre, and the appellants are working since the year 1991-92 without any promotional avenue. The state pay commission and considered the grievances of the ex cadre.
You are reading from where, Mr. Day?
My lord, page number 35, para number 2, my lord. I'm so sorry. I'm so sorry, my lord.
Yes, yes.
So this is my second round of litigation, my lord, when in 2015, the learned divisional, the honorable divisional bench directed the respondent authorities to modify amend the rule. Para number 2 for a moment, my lord. Appellants are working as a receptionist in the tourism department of state of Assam. There are 14 persons working as a receptionist in the entire state. The posts are created in ex parte, ex cadre, and the appellants are working since the year 1991 and 1992 without any promotional avenue. The state pay commission considered the grievances of the ex cadre receptionist and directed the government to encadre them and give them promotional avenues. The state did not accept the recommendation, instead appointed a committee to go into the anomalies. The state committee also endorsed the view of pay commission and directed the appellants and others working in the state post to have to be encadred and promotional avenues have to be given. Now the government did not give effect to the recommendation of the pay anomaly committee with such and such petition was filed with the appellant. Para number 3, Commissioner of the Tourism Department filed an affidavit. Para number 6, my lord, on the next paragraph, next page, it is seen that there are 14%, my lord, page number 36, my lord, para number 6. It is seen that there are 14 persons working in the state post as an ex cadre. A permanent need for the post has been felt, and yet the government has categorized the state post as an ex cadre, which appears to be illegal. The ex cadre post can be created only in the exceptional circumstances where the posting or promotion is to be given to a person that the post is coterminous with his retirement. Here, in this case, that is not the situation. It is therefore directed that, keeping in view of the observation made by the Supreme Court in such and such case, the government should encadre the receptionist post and also should provide promotional avenues, keeping aside some reasonable percentage of the post for promotion and the rest for direct recruitment to the post of assistant tourist information officer. Accordingly, the petition is allowed rules accordingly to be amended within the period of 6 months. My lord, that is in 2015, my lord. They amended the rule in 2017, my lord. I lose out 2 good years, my lord. So thereafter, my lord, will find in page number 38, my lord.
They amended the rule and did what?
They
encadred the post.
Yes, my lord. They encadred the post that.
So the posts were encadred with effect from which date?
9th June 2017, my lord. I have the copy of.
Yes, yes, 1 minute, 1 minute. Therefore, the post in which you are now, your client is now promoted,
Yes, my lord.
that was created on 9/6/2017,
Yes, my lord.
right?
17, my lord.
Now you want that he should be promoted, but should be promoted from a date
No,
prior
my
to
lord.
that.
No, my lord. That grievance, in the second round of litigation has already been taken care of.
Hmm.
So what had happened thereafter, my lord? Why I read this order to given, what had happened to me
Hmm. So
thereafter, my
let
lord.
us now read the speaking order.
Yes, my lord.
Yes,
Yes, my lord.
yes,
For a
yes.
moment, before reading the speaking order, my lord, just one paragraph in page number, for page number 44, my lord, for a moment, my lord.
Hmm.
That relates to my second round of litigation with regard to notional promotion, my lord.
Hmm.
So, page number 7, my lord, sorry, para number 44, para number 7. I'm reading from all the same, the word starting all the same. All the same, considering the fact that the appellant has remained in service for long years without any avenue of promotion, and how in any case, and by now in any case, he was appointed as Assistant Tourist Information Officer with effect from 17/7/2017, he would complete 5 years of service in the post of Assistant Tourist Information Officer in the year 2022. And since the Assam Tourism Service Rule provides that 50% of the post of Tourist Information Officer shall be filled up by promotion amongst the Assistant Tourist Information Officer who have put in 5 years of service, we dispose of the writ appeal by directing the respondent authorities to consider the claim of writ appellant along with others eligible candidates in accordance with law by convening DPC immediately after July 2017, 2022. Thereafter, my lord, what had happened? I filed my 2 representation there, claiming my case to be promoted in the next higher post, that is TIO. Now, as per rule, my lord, because I can be eligible only on 1st January of the year on which I am seeking a promotion. That rule is, my lord, is 14.3.
Mr. Dey, you are going everywhere. What is the issue
My
here?
lord, so what had happened after that?
Hmm.
So, after the second round of litigation, my lord, the Honorable High Court directed to consider my case. Now, DPC, my lord, was convened before I become eligible for promotion, my lord, and rejecting my case, and my case was rejected. That is my grievance, my lord. Apart from that, that I may be given as a supernumerary post, that my prayer is there, my lord. So what had happened on 8th of,
So now you are eligible.
now I am eligible, my lord.
So they will consider your case in the next DPC. That's the order can be passed, nothing else.
My lord, on a supernumerary.
You want to set the clock back.
No,
We'll
my
give a
lord,
reason
no, my
why
lord,
it cannot
that
be.
I cannot do because
It cannot be done.
supernumerary post, my lord, if my
No, supernumerary post is something else.
only on that
No.
one line from the DPC, my
But
lord.
the question of supernumerary, but there are cadet posts for promotees.
So what had happened, my lord, while the DPC was convened in August 2022, they considered this by looking into the entire fact and circumstances in page number 58, my lord. DPC notes that I may be considered to be promoted to a supernumerary post also if finance department and personal B department takes into consideration my EA. So virtually, my lord, as the DPC was convened, your lordship is correct. As the DPC was convened before, so my case was not properly considered, my lord. They declared me immediately ineligible. Now I have become eligible, my lord. And according to the second round litigation EA order, my lord, divisional bench order, the DPC was supposed to be convened as per rules, my lord. So as per rules, I am now eligible, my lord. Page number 58, my lord, the DPC while concluding notes this, that supernumerary post can be created by, in this case, my lord, by looking into the all circumstances, because for last, I am on verge of retirement also, my lord. I'm in July, I will retire, my lord. This person will retire in July 2023, my lord.
Let them consider his case if he's acquired the
My lord.
eligibility. And
Before retirement, my lord,
Just one thing, occupancy at page 44, Lord. A
Page?
specific 44, Lord.
yes,
A specific direction was passed
for convening a DPC immediately after July 17, 2022. So department convened a DPC lordship. Now in the DPC lordship will find why why he was not considered lordship. Lordship will see page 59. Last paragraph lordship.
Yes, I've seen it.
Last paragraph. Lordship, one post was vacant at that point of time, and that post was reserved for STH. So he could not be promoted.
And apart from that, they say he did not meet the eligibility. of
Court
five-
said he is eligible, Lordship. No.
Hmm?
Court said he is eligible. Lordship will see the division bench order, Lordship. Court said as he would become eligible after 5 years, that is, he was promoted on 17/7/2017. He will become eligible on 17/7/2022. That is why court directed to initiate to convene a DP immediately after July 17, Lordship. Page 44.
On that case, my lord, 57 may be looked into, my lord. Because
Just
they
a
have,
minute, let him finish. Yes.
So it was in terms of court's direction, Lordship.
Hmm.
And DPC considered his case. And DPC found one post is vacant for that is reserved for STH. So he cannot be promoted to a post, Lordship, to which category he doesn't belong.
Who was promoted to that post?
Lordship, it was for consideration of his case only. DPC was convened to consider his promotion only.
Hmm.
And the post vacant at that point of time was an STH post.
So who was promoted in that?
Nobody was promoted, Lordship.
Then he has a case.
Lordship, it was
He almost finished his case till you came to his rescue.
no, Lordship.
If there is no candidate for STH, that post cannot be kept reserved. It has
No,
to be
now,
reserved.
Lordship, now it was in terms of court's direction, a DPC was convened.
Hmm.
Now in regular course, Lordship, they will convene the next DPC whenever it is due, Lordship.
Mr. Nayak, you cannot say that as per roster, this belongs to STH. So since there is no STH, we'll keep it vacant, but not consider eligible candidates in the department.
At that point
That
of time,
cannot be done.
on 2nd of January, no STH candidate was there. It is clear from this order, Lordship.
Hmm.
What is the situation today, Lordship? That we don't know.
Then we'll dispose it of with a direction to consider.
Lordship, in due course of time, Lordship, they will definitely, as per their
No,
rules.
he's saying his client is retiring in July. If there is a
Lordship,
vacant,
Lordship, so many similar persons are there, Lordship.
but
If
that's.
just considering
that's
one.
hard
person,
part,
Lordship.
Mr. Nayak, that can't be that it is our choice. We may or may not consider. Promotion is what people work for the rest of their life, for the entire life. Suddenly somebody says, this time we'll not consider for 6 years, and in another case, we'll do it in 6 weeks. That kind of liberty is not available. That is completely arbitrary. If the posts are vacant and if people are eligible, how can you say that it is our choice whether you retire, then we'll consider? That is completely a malafide exercise.
No,
How
in
can that
terms of rule, definitely they will consider, Lordship. That is what I am on.
They will consider within next 4 weeks.
In terms of the rule, Lordship.
Yes.
They will consider in terms, rule says, Lordship, consider DPC after finding out the eligible candidates in the first month of the year, Lordship. Now, it is May, Lordship. So
So
if
he is eligible.
he was eligible on the date of passing this order also, Lordship. 5 years, Lordship. Only situation was that post was not available for him.
No, but how can you keep a post vacant saying that it is
No,
meant for, we
Lordship
will not
separate-
promote
that
anyone?
is that Lordship separate issue. He is not claiming for promotion to that STH post or de-reservation of that post.
No.
He is
posts-
saying create a
posts do not come
supernumerary
with
post.
the
for-
name. Posts do not come with the name written ST.
It is in terms of roster point.
No, that's no.
You one
In
we are
terms of
following-
roster point, the candidates will come in the zone, not a post. If there are eligible candidates who do not come within the zone, in terms of roster point, they will come into the zone of consideration. But no name is written in the body of a post.
No, they are following a separate roster. That 20-point roster, Lordship, every department is following. They are also following. In that post, Lordship, the post which shows vacant, Lordship, it is for reserved for STH. That is what.
De-reserve
That's
it and consider if no candidate is available.
Lordship will
consider-
simply say whenever in the next DPC, Lordship is.
I heard Mr. AB De Learned Counsel for the petitioner also heard Miss MD Bora Learned Government Advocate Assam appearing for respondent numbers 1, 2, and 3. Mr. P Nayak, Learned Standing Counsel, you are appearing for?
Yes, Lord, 4, Lordship, respond number.
The Standing
Finance
Counsel, Finance Department Assam has appeared for respondent number 4. Full stop. The writ petitioner herein is serving as Assistant Tourist Information Officer and is presently posted at Kaziranga. Full stop. According to the petitioner's counsel, his client is due for retirement on attaining the age of retirement with effect from 31st of July 2023. Agreed by the speaking order dated 2/1/2023, whereby his case for promotion to the next higher post of tourist information officer was rejected. The instant writ petition has been filed. Full stop. By inviting the attention of this court to the order dated
2nd January 2020.
7/4/2021, passed by the division bench in writ appeal number 107/2021, referred by the present petitioner as appellant. Mr. Day submits that although the case of his client was considered by the DPC, yet he was not promoted on the ground that the vacancy was reserved only for the STH category candidate. Full stop. Contending that there is no STH candidate in the department eligible for being promoted to the post of TIO, the petitioner has approached this court by filing the present writ petition, inter alia assailing the impugned order. Full stop. Mr. Nayak submits that the case of the petitioner has been considered in terms of the directions contained in order dated 7/4/2021, but since the sole post of TIO was reserved to be filled up only by STH candidate, he was not promoted. Full stop. Similar is the stand of Ms. Bora, learned government advocate Assam. Full stop. This case otherwise has a checkered history in the sense that the petitioner appears to be one of the persons working in an ex-cadre post under the Department of Tourism. Since there was,
1991, my lord.
sorry,
1991, my lord, he's working.
the petitioner was working as a receptionist in the tourism department of Assam since the year 1991. But since it was an ex-cadre post, no promotional avenue was provided to the petitioner. Eventually, in terms of orders passed by this court from time to time, the relevant rules, that is, what is the name of the rule? Relevant in terms of the orders passed by this court from time to time, more
Assam.
particularly, the order dated 23/2015, passed
In WPC
by the
number.
division bench in writ appeal number 16/2015. The relevant rules, namely, what is the name of the rule?
Assam Tourism Service.
Some tourism service rules
1992.
1992
my lord.
was amended with effect from 9/6/2017, and the post held by the petitioner was encountered.
Entered.
Thereafter, he was promoted to the post of assistant
Tourism
ATIO,
officer.
Assistant Tourist Information Officer,
From 17 July 2017.
on 17 July
17,
2017.
page number 38.
As per the rules, the next promotional post is of TIO. And the feeder cadre is ATIO. Full stop. The eligibility condition requires 5 years of continuous service in the feeder cadre. Full stop. Taking note of the grievance expressed by the petitioner, the division bench had
Page number 40.
disposed of the appeal being writ appeal number 107/2021 by the order dated 7/4/2021
2021.
with the following observations, para 7 to court Kulgo, page 44. Full stop. It is not in dispute that soon after the directions passed by the division bench by order dated 7/4/2021, a DPC was convened, but as noticed above, the petitioner was not promoted on the ground that the sole vacancy
No, my lord.
in the.
My lord, that may not be. Page number 57, my lord, may I for a moment look. My lord.
Hmm.
Page 57. So they have noted that 5 years of service has not been completed as per rule. He was second on the gradation list, and thereafter they have noted that ST Hill category could not be filled up. That last part, my lord, may I look.
But the petitioner was not considered. But a perusal of the minutes of the DPC meeting goes to show that the petitioner was not considered for promotion on two grounds. Firstly, that he had not completed 5 years of service in the cadre of ATIO
88.
as on the date of the DPC. And secondly, as per roster point number 14, the sole vacancy in the rank of TIO was reserved for STH, first of. By referring to the minutes of the DPC, Mr. Day has argued that in the meantime, the petitioner has acquired the eligibility, first of. Therefore, the respondents be directed to consider his case afresh, first of. What is also to be noted here in that, if there is no eligible candidate in the department from the STH category, then the respondents cannot deny promotion to a eligible departmental candidate on the sole ground that as per roster point, the
14.
vacancy was meant for reserve category candidate. In such situation, it would be incumbent upon the departmental authorities to de-reserve the vacancy and fill it up with eligible candidate. Consequently, the reserve category vacancy can be carried forward. First up. However, no such exercise carried forward. Since the petitioner has in the meantime acquired eligibility, in view of the earlier orders passed by this court, it would now be incumbent for the respondents to constitute a DPC for considering the case of the petitioner along with other eligible departmental candidates, if any, in terms of the rules. Therefore, this writ petition is disposed of with the direction that within 4 weeks from today, a DPC be constituted for considering the case of eligible departmental candidates for promotion to the post of TIO in the light of the observations made herein above. Writ petition stands disposed of.
Just one observation, Lordship, that this order subject to Lordship, if in the meantime, Lordship, we don't know what is the situation, Lordship. If in the meantime, Lordship, somebody becomes eligible from the STH category, Lordship.
Of course, it's written along with all eligible candidates.
No, Lordship has directed to this.
If no ST candidate is
Lordship, obliged.
there. If no candidate is there, it has to be de-reserved and the reserved vacancy has to be carried forward for future time when eligible. That's the law.
Lordship,
There's nothing to argue on that.
Lordship.
Because you can't say that we will not consider you
I did not.
and we will not even
No,
fill up the.
I did not hear that line, Lordship. That is. not-
Achha, that has been mentioned. Yes, next matter.
Obliged, my lord.
Lordship,
Deeply obliged.
this has been mentioned in the DPC meeting, Lordship. The committee therefore decided to move WPT BC department for de-reservation of the post. You mentioned.
And you write in the DPC. However,
Page
in-
58.
let's see. Let's see the earlier. However, it is also seen from the minutes of the DPC that
Page 58, my lord.
an advisory has been issued to the department to move the WPT and BC department for de-reservation of the post. It's just line to my book. It can be ground or twin ground or reject. However it is.
Obliged.
Obliged.
You have not implemented the WPT and BC here.
Yes.
Personal department I have implemented.
All right, all right. WPT and BC ought to have been implemented. All right.
Obliged.
Obliged, my lord.
Hey, call someone else. Yes.
So, this is also recruitment by the SSC. I have annexed the order.
Huh?
I have annexed the judgment at page 96.
Page 96. Page 97 or similar order. Disposed of. How many candidates?
Four lords.
All of them are eligible.
All are eligible and all are OBC candidate lordship.
All right, just 1 minute. Disposed of. Any other matter in this category?
No lordship.
Disposed of.
May I please, your lordship? Lord, matter pertains to appointment of Anganwadi worker, my lord. Lord, initially the petitioner was selected and appointed, my lord. Thereafter, my lord, the private respondent, my lord, he approached the honorable court, my lord. The honorable court was directed that the matter has to be inquired, my lord. Thereafter, my lord, after inquiry, my lord, the director passed the order that the present petitioner has to be removed from the service. My lord, initially, my lord, the private respondent number, he was ineligible because of
Where is the impugned order?
impugned order at page 56, 49, my 53, my lord. 53 is the order passed by the day.
Proper inquiry was conducted.
My lord, initially, my lord, initially also, my lord, proper inquiry was conducted. And the private respondent found to be ineligible because she was a student, my lord. And later on, after the order of the High Court, my lord, again inquiry is conducted and the same, my lord, authority opined that the, my lord, he is not a student.
Yes, what do you say, Mr. Chakraborty?
Lordship, that inquiry was conducted on the basis of the order dated 25/11/2022, Lordship. In WPC number 4517/21, Lordship. In compliance of that order, Lordship.
Where is that order?
Order dated, Lordship, 55, Lordship.
I could so.
Page 55.
55, Lordship.
Page 55 is not a court order.
The court order is, Lordship,
49.
49, Lordship. Page 49. 49.
So this order is passed as per the court order. You agreed for that.
Initially, my lord, she was enrolled as a student, my lord.
No, that
Board
will
number
see, but
clear, correct.
as of now, this
And-
order has been passed by the
My lord, this system and notice
Compliance
may
with-
go, my
Okay,
lord,
notice,
and-
heard Mr.
and the-
S. Ahmed Lani, counsel for the petitioner. There will be amendments made in the writ petition. By filing this petition, a challenge has been made to the order dated 25/4/2022, passed by the respondent number,
That's number
respondent
two, my
number 2, removing the petitioner from her voluntary service as Anganwadi worker uh, due to appointment of the respondent number 5 in the same post. Full stop. It appears that the impugn order dated 25/4/2023 has been passed in compliance of the order dated 25/11/2022, passed by the learned single judge in WPC number 4517, public 2021. Full stop. What is the ground on which you are challenging?
My lord, the similar authority, my lord, in two opinion has been done. Initially, they said that.
However, Mr. Ahmed submits that the basis on which the impugn order has been passed is wholly arbitrary. Mr. A. Chakraborty, learned government advocate, Assam, prays for some time to offer instruction in that. NOM 6 weeks, since Mr. Chakraborty has appeared and
1 to
accepted
4.
notice for respondent number 1 to 4. No formal notice, extra purpose. Petitioner to take steps for service of notice upon respondent numbers 5 and 6. Heard on the prayer of interim relief. The said prayer will be considered returnability.
In the meantime, my service may not be disturbed. My, he
Returnability.
is yet in service, my.
Next matter, please.
Obliged.
My lord. Oblige, my.
When the present petition has been filed, being aggrieved with the action of the respondent authorities, in my lord, not allowing the petitioner to participate in the physical test, my lord. Or my lord, filling up of certain post, my lord, of constable held by the my lord, staff selection commission, my lord. And the allegation is that my lord, he has impersonated, my lord, in the written test, which they call, my lord, the computer-based examination. And at the
So
bio.
an appeal lies before the appellate authority.
No, my lord, that's the reason, my lord. Lordship will see kindly page 34. 11.5.6.
Yes.
11.5.6, my lord.
Hmm.
Conduct of PET, PST and DME, RME will be the sole responsibility of CAPF. The commission will not entertain any representation, appeal, RTI application, so and so against the decision of PST, PET. And so.
So what the writ court can do now?
Lordship, otherwise, my lord, the entire career of this boy, my lord, 25-year-old graduate boy, it will, my lord, end, my lord, because of this criminal case. They have lost the FIR also. My lord.
Yes.
He was behind the bars for 2 days. He got the bail, he was released.
What is the allegation against him?
Allegation is that, my lord, the biometric, my lord, the left hand thumb impression does not tell you.
And his photograph also, Lordship.
Photograph, my lord, these are the
Photograph
only
and
thing I can place it, my lord.
No, Mr. Gogoi, you see,
I understand, my lord. But
in a writ
my-
petition, what do you expect the court? Why don't you?
my lord, my lord, at least some direction of this honorable court that I may be allowed to, my lord, represent myself with it. Because, my
Represent
lord,
yourself?
before the authority, let them, my lord, reconsider it, my lord, only on this particular decision, my lord. Otherwise, my lord, the entire career will be jeopardized.
What is the decision?
Decision is that, my lord, lordship will find it, my lord, in the FIR.
Hmm.
This is the allegation.
Why don't you file a petition, quashing petition?
Quashing it has been filed.
Where is it?
Yesterday it has been filed. It has been numbered also, my lord. The serial number is 1506 of 23.
You get a stay order, then we can pass here. Otherwise, how can it be done? This will be conflicting situation. You obtain instruction.
But my lord, the only thing is that, my lord, after holding of the medical examination now, which is the last phase, I will be, my lord, debarred from participating. My lord. Some, my lord, protection by one post.
You must get a stay order in the criminal petition, Mr. Gogoi, otherwise we'll dismiss the writ petition.
Lordship.
Nothing can be done.
Then in that case, my lord, we'll try to list it by, my lord, next week. Let it be on Friday next, my lord.
All right.
Some stays.
I had
I would
Mr.
say,
B.
my lord.
Gogoi, letter counsel for the petitioner, peruse the statements made in the writ petition. Mr. Gogoi submits that his client be at least given an opportunity of being heard before the competent authority.
Lordship.
First up, Ms. R. Devi Lanet CGC appearing for the respondents prays for time till 26. Is it 26? 26?
It's 26.
5/2023 to seek instruction on the above issue. one extra copy of the read petition
I
to
will.
furnish to Ms. Gogoi. Let this matter be listed again on 26/5/2023 as a fixed item. You understand, Mr. Gogoi, these are all factual matters.
Yes, correct.
We cannot pass
Yes, yes.
mutually conflicting orders.
Lordship.
If you don't get this stay, withdraw this petition. Nothing
Lordship,
else there.
I will do that.
Yes.
God bless you.
ये tourism में matter करिए, give this in the file. Tourism में Govindo.
My lord, we have taken steps, my lord. Hey. My lord, this matter in my lord dispose of, my lord, I work as a peon in my lord IMDT Borpata then, my lord. And I worked for 4 months, my lord. And my lord, at that time, my lord, my provident fund was deducted, my lord.
No, you have not taken steps.
Well, I have taken
Service-
steps, my lord. Sir. See, my lord. An acknowledgement receipt of stays, my lord, I filed, my lord.
Right, but then the no office note says no steps for service on respond number 2. But what is the relief you are praying for?
My lord, I worked for, my lord, 4 months, my lord, from, my lord, then, my lord, it was, my lord, my certificate, SLC certificate was false, my lord, according to them. Then, my lord, I was suspended, and my lord, I was suspended, and my period is at this stage, my lord, they have deducted my provident fund, my lord, amount for 4 months. That may be, my lord, given to me, my lord.
Well, Lordship, I'm a formal party here. 2-3 is the main respondent, the member, foreigner tribunal, and the accountant general.
No, Provident Fund, who is the controlling authority?
He is the accountant.
So force certificate, you are admitting that it's a force certificate.
My lord.
You are admitting.
Yes, my lord.
Okay, we'll dispose it of.
My lord.
Make an application, it will be
My lord.
considered in accordance
My
with law.
lord.
You take on hard, Mr. SSS, Triple S Rahman, and counsel appearing for the lead petitioner. Also heard Miss MD Bora, learned government advocate Assam.
For
Appearing
one
to
minute.
Respond number 1, none for respond numbers 2 and 3. The facts of the matter, in a nutshell, is that the read petitioner hearing was earlier appointed temporarily in the post of a grade 4 bracket peon under the IMDT tribunal, illegal migrants determination tribunal, Borpeta. And thereafter, his services were regularized with effect from. When was he appointed?
My lord, 11/3/2004, my lord.
That is regularization.
My lord, yes.
Appointed.
Appointment at my lord. Not appointment, my lord, I have not annexed, my lord.
But can you tell the date? You also don't know.
Yes, my lord. It is. At in 2004, my lord. 2004, my lord.
Sometime in 2004,
2004, my lord.
and thereafter his services were allegedly regularized with effect from 11/3/2024. 2004, first of all. While he was serving as a peon, it came to light that the petitioner had relied upon forged marksheet and other documents for securing his appointment. Full stop. As such, the petitioner was suspended from service and an FIR was lodged based on which GR case number 156/2004 was registered under section 468/420 of the IPC. First up, it appears that charge sheet has also been submitted. But on completion of trial, the petitioner was acquitted in respect of the charge by giving him the benefit of doubt. First up. In the meantime, the petitioner has not been continued in service. First up. Therefore, the only prayer of the petitioner's counsel at this point of time is that he be permitted to withdraw the Provident Fund deposits made during the period of service of the petitioner. The petitioner be permitted to withdraw the Provident Fund deposits since there is no departmental or legal proceeding pending against him as on date. Ms. Bora, learned government advocate Assam, has not opposed the said prayer. In view of the above, this writ petition is being disposed of with by granting 4 weeks time to the petitioner to file to submit appropriate application before the competent authority.
Accountant General.
The,
Accountant
that is-
General.
he will figure out who.
My lord.
Competent authority seeking now with a prayer to permit him to withdraw the PF deposits. First up, if such an application is filed within 4 weeks from today by enclosing a certified copy of this order, the application submitted by the petitioner be processed in accordance with law and be disposed of with a speaking order within next 4 weeks. With the above observation, writ petition stands disposed of.
Obliged.
Obliged, my lord.
The next 4 weeks upon proper verification of his claim.
Well, in this case, my lord, after 24 years of service, my lord, expiry, no, my lord, today itself, he is directed to appear along with mother. Because process has been started now. He was initially 24 years now, my lord, after passing of his matriculation examination. Today itself directed to appear before the director. I have collected the letter, my lord.
What is it?
Only APR, not regarding
to APR.
appointment. Because he has made
Not
another
for
representation
appointment.
before the
Then you withdraw
authority.
it, otherwise I'll dismiss
Yes,
it.
my lord.
You
There's
withdraw,
no case.
otherwise I
Today,
can,
he is given that liberty.
I cannot keep it pending. You have to withdraw and go through the process. Because the orders have been passed 19 years, 18 years.
Yes, my lord. Recently, process has been started.
What do you want to do?
My lord, let me on next Friday, my lord, Friday.
You withdraw or I'll dismiss it. There is no way out. You go through this and then
Yes, my lord, then your lordship. may proceed.
Mr.
By-
Adas,
by
learned
giving the
counsel for the
documents.
petitioner submits that only this morning, the
Yes.
Director
Director General of Police, my lord.
Director General of Police, only this morning, a communication has been received by the petitioner from the office of the Director General of Police,
Yes,
asking them to appear
yes.
before the authorities in connection with the application seeking compassionate appointment, and therefore he be permitted to withdraw this writ petition with liberty to file afresh as and when a proper cause of action arises. Ms. M.D. Boral, and Government Advocate Assam, appearing for the state, does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for. We will say nothing else now.
The copy of
My
this,
lord.
my lord.
In fact, lordship, his application before the DGP is base 15, my lord. Regarding his stay brother has been appointed regarding all that.
Let him,
My lord.
whatever happens,
My lord.
we will not
That's
comment on it.
My lord. Obliged, my lord.
But this 18 years, 19 years,
Yes,
20
my lord.
years, 50 years,
This copy of this letter, my lord, they have started this process.
they should not have started.
Yes,
this
my
process.
lord.
That's why,
Last in the month of January, they have started.
what is happening?
No, lordship, this letter does not reflect that they have been, they have directed to appear for the compassionate appointment process. They have been directed to appear regarding the objection made by the petitioner regarding his stepbrother who was appointed as the
All right,
compassionate
let him,
appointment.
but these are all frivolous.
My lord, my
petitions.
lord,
He has submitted,
this is not initiation of the process of
These
compassionate
are,
appointment.
Mr. Das, these are
Yes,
all frivolous petitions.
My lord,
You are just wasting the judicial time of the court
my lord.
and getting 1 or 2 orders here and
Yes.
there, creating a chaos.
Yes,
How can there be compassionate appointment?
yes.
Father died in 98. Today you want a direction in 2023? to appoint someone in compassionate appointment. How is it permissible?
As per law, it is not permissible.
Then why are you filing petitions?
Because my
You
lord,
want what? You want orders not as per law.
no, my
Reverse the
lord,
law.
only for consideration, representation. disposal,
Nothing.
madam.
There has to be a right, only then there can be consideration. Yes, yes.
Oblige, my lord.
May please, your lordship. Lordship, I may be allowed to withdraw the petition, lordship.
But he should be asked, why is he withdrawing the
Why you
petition?
want to-
In
Just
the
happen.
morning, I have came to know that she has applied in for the SC caste for through her husband's certificate. So I was really surprised from this matter, so I may be withdraw this petition because it's not proper to place this petition, lordship.
Then dismissed is not.
Dismissed.
No liberty.
All right.
No liberty, lordship.
Mr.
K Islam.
K. Islam Learned Counsel appearing for the writ petitioner submits that he has received instructions from his client only this morning not to press this writ petition, and therefore the matter may be dismissed as not pressed. Mr. UK Nair Learned Senior Counsel assisted by Mr. K.
K.
Kalita
For
has
228, madam.
on behalf of respondent numbers 2 to 8. Mr. S.S. Roy Learned CGC is present on behalf of the respondent number 1. In view of the prayer made by Mr. K. Islam Learned Counsel for the petitioner, this writ petition stands dismissed as not pressed.
Lordship.
For admission, item only.
Lordship, may I please your lordship? Lordship, may I pray for time being Passover of the matter, your lordship? I am on behalf of Mr. S.P. K.R. He is on leave. I think S1 number 5 advocate is also on leave.
What do you want? Time or
Time being Passover, your
time being
lordship.
passed?
I can, if it is not difficult, I mean, objectionable to them, my lord, I can start, it will
No,
take
but
some
how
time.
long will it take?
I will take around about 15 to 20 minutes.
Then in any case, we'll take it after other matters are over. Passover is automatic, yes,
Oblige.
time being.
Item 15.
May I please your lordship? Lordship, in this case, the father of the petitioner was working as a lordship grade 4 employee in the office of the lordship respondent number 4. And lordship, after the who expired in harness on lordship 17/11/2014, thereafter the petitioner applied for compassionate appointment on 5/12/2014. Accordingly, his application has been lordship forwarded to the lordship deputy commissioner on lordship 17/12/2014 by the lordship respondent number 4. And lordship, GLC has recommended the case of the petitioner, that is in page number 23, lordship, on 25/2/2016, lordship. Page number 23, and operative parties, lordship, 24 and clause 3, lordship. May I read, lordship?
1 minute. Due to want of vacancies.
Lordship, this is not, GLC has recommended because 2 vacancies are there. Lordship, in page number 24, lordship. Operative person is lordship, clause 3. And lordship, case page number 25, lordship, Roman number 2, lordship, 2015, 2 numbers of post and eligible vacant post, lordship, 1 post is vacant, lordship.
What do you have to say, Mr. Kalita?
Lordship, last time this honorable court has asked me to get the latest position about the vacancy position. So I got it. And as for this, lordship, there is no vacancy as such because there is only 1 seat they can get. Because total seat is, position is 10. So there is 1 post only they get. So 3 persons are already working
On compassionate.
on compassionate ground. So that is
A rule of lordship compassionate appointment, the provision which has been applied by the government while decided the case of the petitioner, that they have followed the 2015 OM. And the case, whether the restriction of 5% in the case of filled up of compassionate appointment indicates only 1 vacancy, whether that restriction will apply or not In this regards, Lordship, the Honorable Court has already decided in the case of Kamal Krishna Talukdar that which rule will be applicable in WPC number 1914/2020. The Honorable Court was held that, Lordship, since the restriction of 5% will not applicable as by virtue of the OM dated 9 September 1983, which is applicable in the case of the petitioner. And in that sense, Lordship, the case of the petitioner has been recommended by the DLC and clearly stated that there is no restriction applicable in the
Which
case
is
of
the vacancy pointed out?
Lordship.
Show the vacancy.
Yes, Your
Please
Lordship. Lordship, page number 25. Page number 25. This is the type copy of the Lordship DLC, Lordship.
Yes. Which is the vacancy against which your client's name was recommended?
Lordship.
Which is the vacancy against which your client's name was recommended?
Recommended, Lordship, on Lordship, one post that is in grade 4 post, Lordship.
Where is it? Where does one find it?
Lordship.
Where does one find it?
Lordship, that is in page number 25, Lordship, that has been recommended,
Well,
Lordship.
I will hear it in due course. These matters.
Lordship,
nothing
because
to do.
in another page also, your Lordship will find, Lordship, that there is a clear indication that there is a vacancy in the post, Lordship, in page number, Lordship.
Mr. Sharma, please speak about your case. They say there is no vacancy. You have to establish that there is a vacancy and
Yes,
this is a
Lordship.
constant. Where
Yes,
is it?
Lordship, that is what, this is the vacancy position, Lordship. The one,
Then these matters are clubbed together in matters where DLC recommends, SLC says no vacancy. That is what we will have to deal with because lot of cases are coming.
No, Lordship, what has happened is that, recommendation came in 2014. In earlier to that only, in 2010, 2001 and 1995.
No, Mr. Kalita, point is, when the DLC makes a recommendation, is it not required to look into the vacancy position?
Absolutely, Lordship.
Then if they say that there is a vacancy and recommended, then how the SLC later on says there is no vacancy?
So as no, that vacancy position has been.
This is generating a lot of litigations.
Lordship.
And these are all people, they need to get an answer this way, that way.
That's
DLC says recommended for appointment against grade 4 post. SLC says no vacancy. The DLC is supposed to look into the vacancy in that department.
While referring to it only that they should.
But what happens to the, why do they refer? Why do they recommend if there is no vacancy?
Yes, the vacancy arose in 2014 and 15,
Right.
two vacancies.
Right.
But like already they are 3 people are working. So total post strength was 10. So 3 people are already working. So but vacancy arose later on, 2014 and 15.
So are these
So
things
they-
on record in the form of affidavits?
This I have got recently. This is not on
Then you
record.
file an affidavit.
I mean, I'll have to file an
For a moment, your Lordship may kindly come to page number 32. When the case of the petitioner has been forwarded to
Heard
the
Mr. D.
DLC,
Sharma,
Lordship.
Learned Counsel for the petitioner, also heard Mr. A. Kalita, Learned Standing Counsel, Industries Department, Assam. We appear for Industries
Lordship.
Department, who submits on instruction, written instruction dated 6/5/2023. That although that there are total 10 vacancies of grade 4 posts, full stop. Therefore, although therefore, only one vacancy would be available for being filled up by way of compassionate appointment. However, at the relevant point of time, although there was a vacancy, yet 3 persons were already working
there.
on compassionate ground, on being appointed on compassionate ground. Mr. Kalita, however, seeks 3 weeks time to bring those facts on record in the form of an affidavit facilitating disposal of the writ petition. File an affidavit that
7 days. He has been made to pay a fine of 7 days pay fine. And it has been regularized as half pay leave, my lord.
yes.
Now, my lord, that is what is under challenge in this petition. They filed their affidavit in opposition. One of my arguments is that the absence on which I have been taken, my lord, that is not a defined misconduct in the rules itself. One leg of argument is there. The second leg of argument is that when they admit that I had medical grounds for not reporting back on time, that matter was never considered while imposing the punishment upon me. They simply went on the ground that I was absent. The Honorable Supreme Court in a few cases have said that once it is found that I give some ground, either they have to say it is not sufficient enough or these are false grounds. But non-consideration of the grounds at all perhaps should not sustain the punishment. May I pre, can be taken up on a non-miscellaneous, my lord, we can also have some judgments prepared, my lord. Even on the next week, my lord, I'll be prepared with it.
Mr. R. Majumdar, learned counsel for the petitioner, as well as Mr. P.S. Locker, learned CGC, appearing for the respondent, submits that this matter can be taken up for disposal at the stage of admission hearing and therefore be posted again after 2 weeks on a non-miscellaneous day. In view of the above, register to list this case on a non-miscellaneous day for admission hearing after 2 weeks.
My lord. Obliged.
The issue pertains to, my lord, non-communication of SCR. For which, my lord, my third MSP benefit was curtailed, my lord. Yesterday also, my lord, a similar petition was disposed of, my lord.
Heard Mr. B. Patak, learned counsel for the petitioner, also heard Mr. S.S. Roy, learned CGC, appearing for the respondents. Full stop. The facts involved in this case is to the effect that the writ petitioner hearing had retired from service as Havildar, stroke GD, bracket general duty, on attaining the age of superannuation with effect from
Securely.
When did he retire?
2017.
Or is he still in service?
No, my lord. Retirement.
With effect from 1/8/2017, after rendering 32 years of continuous service. First up. During the course of his employment, the petitioner has been the recipient of as many as 2 MSP benefits. First up, however, the third MSP was denied to him due to certain adverse entries in the SCR pertaining to the relevant years. Full stop.
15-16. For the year 2015-16.
That is 2015 and 2016. Full stop. The case of the petitioner is that the respondents would not have denied him the benefit of third MSCP by relying upon uncommunicated adverse entries in the SCR. Full stop. In support of the above stand, the petitioner's counsel has relied upon 2 decisions of the Supreme Court in the case of Dev Dutt versus Union of India and others reported in so-and-so, and Sukhdev Singh and Union of other, you'll get it here in this order, so-and-so, reported in so-and-so, to submit that uncommunicated adverse entries in the SCR cannot be relied upon so as to deny benefits of promotion / MSCP to the employee. Full stop. The respondents have filed affidavit, thereby virtually admitting that uncommunicated adverse entries in the SCR of the petitioner in the form of the grading of within course average, unquote, had been relied upon to deny him the benefit of MSCP. If that be so, in view of the law laid down in the case of Dev Dutt Supra and Sukhdev Singh Supra, it is established that the respondents have arbitrarily denied the benefit of third MSCP to the petitioner. Full stop. In view of the above, this writ petition is hereby disposed of with a direction upon the respondents to reconsider the claim of the petitioner for grant of third MSCP and pass appropriate orders therein in the light of observations made in herein above, without relying upon the uncommunicated adverse entries in the form of average, within course average in the SCRs for the years 2015 and 16. Full stop. The exercise as directed above, be carried out and completed within a period of 3 months from the date of receipt of a certified copy of these orders. With the above observation, this writ petition stands disposed of.
May I please, your lordship. Lordship, in this case, we were directed to take instruction, lordship, instruction not received, some more time maybe.
What is the matter?
The issue, my lord, was pertaining to whether they will be covered under the old pension scheme or new pension scheme.
Yes, lordship.
The last occasion I pointed out, my lord, pursuant to a judgment of the Delhi High Court, my lord,
Let her have another 3 weeks. then we'll
the
discuss.
DOPT has, my lord, now given the option of, my lord, exercising an option as to.
3 weeks
whether-
last chance. Mr. B. Pathak, learned
Right.
counsel is present on behalf of the petitioners. By referring to the order dated 26/4/2023. Passed in this case, Ms. R. Devi, learned CBC submits that instructions as called for are still awaited. Full stop. Therefore, 3 weeks further time has been prayed for in this case. Prayer allowed as a last chance. Let this matter be listed again after 4 weeks for admission. We'll take it up for disposal next.
My lord. In fact, Assam Rifle has already started the exercise.
I don't know why she's not being.
Annexer 2, my lord, I have submitted in my additional
All right.
affidavit.
One more chance.
My lord. APM.
May I please, your lordship. Lordship, I would pray for passing over the matter for the time being, madam.
Time being, why? What is the matter about?
But a warning has been issued for not attending classes, my lord.
Huh.
That's all.
Warning is what? It's not a punishment.
Not punishment. You have not recorded anywhere in India with service book, my lord.
My lord, the warning was not sent according to the procedure established by the Assam Agriculture University, my lord. Their rules.
What is the procedure? Let us see. Where is the warning? Let us see.
Warning, your lordship will find that they have enclosed, my lord, that is.
Page number.
Page number 16, my lord. By the dean, my lord. One day, my lord, he was absent, my lord, 16 March 2000. So you are not to repeat similar mistakes in conducting assigned class in future.
It's not a penalty.
Yes, my lord. But
Then-
however, my lord, there is sent to the annual confidential report of the petitioner, my lord, without following the due procedure. Ma'am.
No, we have not, we have admitted in our affidavit. We have not recorded nowhere.
No entry, no adverse entry in the SCR on the basis of this. What is the wrong? What is the problem? We'll record her submission and close it. Take down heard, Mr.
Mr. PH Kumar, my lord.
P.H. Kumar,
Yes, ma'am.
Learned Counsel appearing for the writ petitioner. Also heard Mr. P. Kotapi, Learned Counsel assisted by Mr. You are with him.
My lord, I'm waiting for respondent number 5.
5, my lord, that is
Yeah,
dean,
Mr.
my lord.
P. Kotapi, Learned Standing.
For 1 to
Counsel,
4, ma'am.
Assam Agriculture University, appearing for respondent 1 to 4, and Mr. B. Chaudhary,
For respondent number 5, my lord.
counsel appearing for the respondent number 5. Full stop. The writ petitioner hearing is serving as a professor in the Department of Extension Education under the College of Veterinary Science from Assam Agriculture University. Full stop. On 26/3/2021, the Dean of the University had issued a letter to the petitioner warning him not to repeat his similar mistake of failing to conduct the assigned class on 16/3/2021 from 8 to 9 AM. Full stop. Assailing the state communication, the instant writ petition has been filed. Full stop. Mr. Filed internally contending that the warning has been issued without following the due process as per the rules. Moreover, the petitioner's counsel has also argued that based on the aforesaid communication, an adverse entry will be made in the ACR of the petitioner. Full stop. The aforesaid assertion of the petitioner has been stoutly denied by Mr. Kotaki by submitting that there is no penalty involved upon the imposed upon the petitioner, and the communication dated 26/3/2021 is merely a warning which is in the form of an advisory. Full stop. Mr. Kotaki further submits that there is no question of including any, there is no question of including any adverse entry in the ACR of the petitioner merely on the basis of the communication dated 26/3/2021, and therefore the writ petition is without any basis. Full stop. Similar is the stand of Mr. Chaudhary, learned counsel appearing for the respondent number 5. Full stop. A plain reading of the communication dated 26/3/2021 bracket annexure C leaves no room for doubt that by taking note of the fact that the petitioner had failed to conduct a class on the 16th of March 2021, bracket VAE class, bracket close, capital V, capital A, capital E, and class, bracket close, from 8 to 9 AM, the dean of the university, that is the respondent number 4, had issued a warning to him not to repeat the mistake of failing to conduct assigned classes in future. Full stop. By the language employed in the communication dated 26/3/2021, it appears that the same is in the nature of an advisory to the petitioner. Full stop. Therefore, this court is unable to agree with the submission of the petitioner's counsel that the communication dated 26/3/2021 was stigmatic in any manner, more so in view of the fact that the petitioner's counsel has not denied that his client had failed to conduct the VAE class on 16/3/2021 without any just explanation. Full stop. In view of the above and considering the categorical assurance given by the learned standing counsel for the university that no adverse entry would be made in the ACR of the petitioner on such count, his writ petition stands disposed of as not maintainable in the eye of law. In the eyes of law.
May I please your lordship? Lordship, in this case, the present petitioners were initially working as a contextual worker since 1994, my lord. And in the year 2000, their posts were regularized. After getting appointment, they were joining, and without assailing any reasons, they were cancelled from their posts. And subsequently, they were approved before the Honorable High Court for the first time in the year 2000 by filing writ petition 7146, your lordship. And that writ petition was clearly directed to consider their post and by considering their upper age also. And without considering their judgment also, your lordship, again appointment was published. And second time they were approved before the Honorable High Court. My lord, kindly may peruse at page 67, your lordship. Second order, page 67. Relevant portion is at page 73, page 67, your lordship.
Yes, who is appearing for the department?
My lordship.
What is your stand?
Lordship, in WPC number 7146 of 2000, it was disposed of with a direction that in case of vacancy of grade 4 exists, but at that time it does not exist, lordship. It is not vacant any post.
Now?
Lordship. Now, as per our affidavit, lordship, the director has not yet received any directions from the higher authority to consider their case. So lordship may direct the higher authority.
Respectful submission is that in the year writ appeal also subsequently.
They have filed so many writ appeals also.
Two writ appeals also clearly directed to consider their post and condone their upper age also, my lord.
And in WPC number 4199/2005, it was direction was shall consider their cases for condonation of age work by submitting their representations, individual representations. I think they have not filed their.
No, but is there any recruitment process now?
The recruitment process has not.
You cannot be appointed.
No, my lord,
No question, no direction can be
Yes.
issued to appoint you.
my lord.
That is not permissible under the law. So if you want a direction to consider your application for age relaxation, that we can consider.
My lord,
Hmm?
that can be.
But there is already a direction here.
Yes, my lord, in the year, in read appeal, my kindly may peruse that page 74, my lord.
No, what is the prayer in the writ petition?
Read petition, my
Prayer-
prayer
prayer
is
is
to
to
consider the
appoint there.
appoint as to appoint them.
No, how can it be done? Appointment is only
Cannot be
through
lordship.
proper process of selection.
Then may your lordship may give a direction,
No direction. Where as and when a recruitment process is initiated,
my lord.
you make application for condonation of upper age and respect, depending on merit of each case. 1910.
My respectful submission is that, my lord, in the read appeal, clearly directed to appoint them within 4 months, my lord.
Where is it? Where is that clear?
At page, read appeal, kindly may peruse that page 74, my lord. And operative part will is at the last page 86, my lord, at page 86. Paragraph 30. Last page, my lord, the read.
So what has happened after page 86 direction? Within
No,
4 months
Here it
selection?
is, applicants shall not be disqualified if they do not possess the higher secondary qualification as per the 2006 orders. So earlier it was
No, please
matriculation.
go ahead, read next two sentence, please read.
In the event the applicants are found to be overaged, necessary relaxation may be made.
Then
the selection process as indicated above should be completed within a period of 4 months from today. As the appointments are.
No. What has happened to the selection process?
That I do not know, lordship.
Then this
My lord.
case, please take your seat.
My lord.
Then it is a case of contempt. Heard Mr. So-and-so learned counsel for the petitioner, also heard Ms. D. Bora learned standing counsel, health and family welfare. Department
Lordship,
as well.
may I submit? They have to file applications, lordship, for their relaxation of their.
But first you have to carry out a selection process. To praise for and it's granted
In
2 weeks
that
time
writ
to
appeal, I think they are not
specific
particular. lordship.
instruction and appraise this court as to what action has been taken by the department in compliance with the directions contained in para 30 of the judgment and order dated 19/10/2021 passed by this court in writ appeal number
357.
357, 2009
357 of 2009
and
passed by
358,
writ appeal
2000.
number 2000. Let this matter be listed again after 2 weeks. You obtain instruction if nothing has been done. There is a case of contempt. We'll drop contempt proceeding. What can be done? There is a direction issued. Yes.
Lordship.
Obliged.
Yes, who is there? Oh, we'll take it up little later. This matter will take time. Yes.
In this case, on last day, Lordship directed me to obtain instruction as regard whether approval of finance department was taken or not before permanently retaining the post. Lordship, that instruction is awaited, Lordship. They are looking for the files, Lordship. Lordship, subject to Lordship convenience, Lordship may take up this matter in the next week, Lordship. Any day, Lordship.
My lord, always finance department comes up with
That
this type of
much only,
submission, my lord.
Mr. Khan, we have to find a solution. You are only interested in getting an order from the court. We are interested in doing justice. We have to figure out what has happened. Heard Mr. F. Khan, Learned Counsel for the petitioner, also heard Mr. P. Nayak, Learned SC, Finance Department, also who pays for another 3 days time to seek specific instruction from the Finance Department as to whether any approval was taken from the department post issuance of the appointment order to the petitioner. Since the
Lordship, here the issue is, they have, judicial department has permanently retained the post, including the post of sweeper. That before taking that permanent retention order, Lordship, whether approval of the finance department,
before
permanently retaining the post.
permanently retaining the post of sweeper in the concerned department. But in any case, Mr. Nayak, you please come prepared. If the post is there, we'll uphold the appointment regardless of finance. This is your internal matter. You sort it out.
Lordship.
If the post created is there, just because finances don't appoint any sweeper, that will not take away his right. You take action against the officer in the judiciary who has done it. Whatever you can. Why should some innocent person suffer? It's a sanctioned post, advertised. He participated, he was selected, he was appointed. What went wrong inside the department? For that, why should he suffer? Know it very clearly. This is the view of the court. And next day we'll pass the order. Just that you should not feel that the court has not given you enough time to come up with answers. If you could wait for 3 years, you could wait, you can wait for another 3 months. But we are very clear in our mind. The public doesn't know what are your internal mechanisms.
Yes, that is.
So if it has not been done, not been done. You take your own remedial measures. He cannot be made to suffer.
Item 24.
Obliged, madam.
Yes.
For sure, I'm appealing for the petitioner. The respondent side, they took time for filing affidavit in opposition, but till date, it has not been filed.
Then we'll dispose it of. What is the matter?
For appointment, your lordship.
Appointment.
Section 11 petition.
Who is the CGC calling?
Item 25.
Yes.
Sorry, my lord, we need some time to file.
But you are taking time again and again.
My lord,
This
yes,
time I will not grant you time.
I got information today, my lord.
This time I will grant you time till 2 o'clock. The court is being taken very lightly. I have seen the orders.
Yes, my lord.
Yes, these are arbitration matters. The urgency is always there in this case. You will get time till 2 p.m. Whatever you have to say, you say, and I'll pass the order, disposing it off. This matter will be taken up at 2 for disposal.
Item 25.
My lord, here, my lord, my name is not reflected in the cause list, my lord.
So you are not aware of the case.
Yes, my lord.
I thought you will say you have not come to the court today. On the, you want adjournment?
Monday, my lord.
No, at least 3 weeks. On the prayer of Mrs.
And the respondents have taken time.
Otherwise, lordship, I would not have objected. The appointment is stayed.
What is the matter? Let us see.
No, not to the lordship, but but not.
No, but what is the matter?
Matter, lordship, some appointment of Anganwadi worker. And some complaint we received from the public. Accordingly, that was stopped, lordship. The publication was stopped.
The respondents were supposed to file affidavit.
So, lordship, I have received that much of instruction, and because of the interim order passed by this honorable court, it was stayed. But I have inquired today itself over telephone that what inquiry you have conducted. That I yet to get, lordship. So,
we'll have it on 29th May.
Lordship.
On the prayer of Mrs. S.B. Chaudhary, Mrs. S.B. Chaudhary, Learned Counsel for the petitioner, and Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, appearing for the state. This matter be posted again on 29th of May,
Lordship.
2023, as a fixed item.
Much over.
Item 26.
May I please your lordship?
Yes.
Lordship, in this case, the petitioner has been appointed as a lordship grade 4 employee in the office of the respondent number 6 lordship. Though the initially petitioner has been appointed as a grade 4 employee, but since the date of initial appointment, he has been engaged as a lower division clerk also to discharge duties of a junior account assistant lordship. And his appointment was lordship on 12/8/1991. Whereas the lordship respondent authority has now they have filed an affidavit which reveals that the person who are super junior than the petitioner, they have been promoted in the year 2002 and as well as in 2010. Whereas the case of the petitioner has not been considered, who duly without any additional pay lordship has been discharging the duties of a lower division clerk. And the order itself reflects that lordship in page number 30, your lordship will find lordship, he has also discharging the duties of a lordship grade 4 employee lordship. Whereas the rule says if a person is senior and join within the 15 days of his appointment, he will be senior for consideration of his promotion lordship.
Yes, what do you have to say, Mr. Sharma?
Lordship. Whereas I am going to retire lordship in the month of December lordship.
Lordship, we have filed our affidavit in page 49.
Yes.
But I think Lordship, some additional affidavit is required.
No, we'll dispose it of today.
Lordship, page 48, paragraph 4. Statements made in so and so, as per Rule 5.3 of the Assam Treasury Establishment Rules 1993, promotion of grade 4 to the cadre of lower division assistant is to be made by direct recruitment and by promotion in the ratio of 80:20. As per our office records, it seems that already 3 numbers of grade 4 employees of the Treasury have already been promoted to the next higher cadre of so and so. These 3 persons. And it reveals that the promotional quota of the LD assistant in the Treasury has already filled up. The 1 number of vacant posts of lower division is kept reserved for direct recruitment.
So then what to do?
Lordship, there is only 1 post. As per the affidavit itself reflects that there is only 1 post. If the department can consider to fill up that post, Lordship, consecutively in the year Lordship itself, page number 49, your Lordship will find in the affidavit in opposition filed by the respondent number, Lordship.
5.
Lordship,
Where is it mentioned about quota, promotional and direct recruitment?
At page 49, Lordship.
No, in the rules.
Rules, Lordship, I have not.
Your Lordship will find the rules affidavit in reply filed by the Lordship petitioner in page number Lordship 62, Lordship. Particular person is there, Lordship.
Page 62.
Yes, your Lordship.
What particular?
Page 62 of the affidavit in reply. May I read, Lordship?
Rule 3. Recruitment to the cadre of lower division assistant.
So more than 20% is already occupied.
Lordship.
Lordship?
More than
No,
20
Lordship, this is not the case. As per the affidavit submitted by the respondent authority, their stand is that there is only 1 vacancy or 1 post. And that is lower division post is only 1. But the thing is that
that is not
that
the case.
post has been filled up consecutively by way of promotion, Lordship, in the year 2002, in the year 1997, when it has been, it will vacant, Lordship. And the thing is that the person who has been engaged in the post of lower division assistant since the initial appointment, Lordship, he has been
How
depriving.
many posts in the cadre of LDA in the treasury? These are all district-based cadre, is it?
Lordship.
So
but
it will
it-
be Lakhimpur treasury.
Yes.
How many posts of LDAs are there? Any idea?
No, Lordship.
Huh?
No idea. But from the affidavit, it reflects that three posts, they have promoted already three. Only one post is lying vacant, that is for the, by way of direct recruitment. The promotional post has already been.
But how it can be three? The rule says that only 20%. So that
That
means
is why, Lordship, I have stated that most probably additional affidavit. 80:20.
we'll ask them to consider his case as per the rules.
Lordship, that should be.
Take necessary
That will
steps.
be,
But
that will be
Mr.
better.
Sharma, learned counsel appearing for the Mr. V. Sharma, learned counsel appearing for the writ petitioner. Also heard Mr. H. Sharma, learned additional senior government advocate Assam appearing for the respondent numbers.
Lordship, finance account, treasury officer, 4 and 6, 4, Lordship,
Numbers. Only respondent number 4.
4, Lordship.
Mr. A. Chalia, learned standing counsel finance department Assam has appeared for respondent numbers 1, 2, 5 and 6. And Miss, your name please?
On behalf of respondent number 2.
Tenlung.
Tinlung.
Write it. Appearing on behalf of the respondent number 2. Full stop. The writ petitioner hearing claims to have been appointed as a peon under the Dhokua sub treasury in the district of Lakhimpur on 12/8/1991, and since then he has been working in the same post without any blemish to his reputation. Full stop. It is also the claim of the petitioner that although he was holding this substantive post, although he was serving in the substantive post of peon, yet due to lack of manpower, the petitioner has been frequently asked to discharge the duties of a lower divisional assistant and or junior account assistant in the office of the treasury officer, that is respondent number 6. Full stop. According to the petitioner, he is entitled for being considered for promotion to the post of regular promotion to the post of LDA as per the provisions of the Assam Treasury Establishment Close Service Rules, 1993 for short rules of 1993. However, despite the existence of vacancy, the petitioner's case has not been considered favorably for promotion to the post of LDA. Although he has been working in the same post for nearly 31 years till the time of filing of the writ petition. Mr. Sharma submits that the petitioner is a graduate and fulfills the requisite qualification norms to hold the post of LDA. First up, notwithstanding the same, and despite the fact that his client is due for retirement on attaining the age of superannuation in the month of December 2023, no action has been taken to promote the petitioner to the post of LDA. Stop. Mr. Sharma, learned additional senior government advocate Assam, on the other hand, has invited the attention of this court to the pleadings in paragraph 4 of the counter affidavit filed on behalf of the respondent number 5 to submit that out of the 4 posts of LDA, 3 persons are already working as LDA, and the 1 vacant post is meant for direct recruitment. First up. Therefore, the case of the petitioner would not be considered for promotion to the post of LDA. Post of. However, what would be significant to note here in that, as per the provisions of Rule 5 bracket numerical 3 of the rules of 1993, only 20% of the post of LDA can, out of the total cadre strength, can be filled up by way of promotion. Posting. Therefore, if the total number of posts of LDA is 4, then also it is not understood as to how 4 can as many as 3 promotees would be occupying those 3 posts of LDA. First of the said aspect of the matter is not clear from the pleadings available on record. First of it is also not clear as to whether all the 3 candidates in the post of LDA presently serving under the respondent number 6 are promotees, or any of them have been, or any of them is a direct recruit. First of since law is firmly settled that right to be considered for promotion is a fundamental right, and considering the fact that the petitioner has rendered more than 3 decades of service without any promotional avenue, and also in view of the fact that he is due for retirement with effect from retirement in the month of December 2023, this court is of the opinion that instead of keeping the writ petition pending any further, a direction should be issued to the authorities to examine the claim of the petitioner in the light of the provisions of rules of 1993 and take appropriate action in the matter. In view of the above, this writ petition is being disposed of with a direction upon the respondent numbers 4, 5, and 6 to examine the claim of the petitioner for promotion to the post of LDA. And on such examination, if it is found that the petitioner is entitled to be considered for promotion as per the provisions of rules of 1993, and that there is a vacant post of LDA in the establishment of respondent number 6, then in that event, appropriate steps for consideration of his case by a duly constituted selection committee, along with other eligible candidates, be taken in the matter. First up, the aforesaid exercise be carried out and completed within a period of 3 months from the date of receipt of a certified copy of this order. Writ petition stands disposed of accordingly.
Only one submission, Lordship, the affidavit in opposition filed by the respondent, Lordship, it clears that, Lordship, the person who has been promoted to the post of LDA, their initial appointment is, Lordship, they are junior to me, Lordship. They have appointed in the year 1993, whereas they have.
That's right, but you have not challenged their promotion.
We have to challenge that.
That was not,
That aspect we
only
cannot-
that observation may be given, Lordship, otherwise.
You are not challenging them. You accepted that they are junior, they can be. How can we go into that? This will be a stray order. Judges cannot pass stray orders. Yes.
Highly obliged, Lordship.
May it please, your Lordship. Lordship, in this matter, in the IA 796/2023, I am seeking a week's time to file my reply, your Lordship. In the IA.
There is an improvement, if he has the order is like this, the recruitment was held, a PWD quota was earmarked for the whole thing. Now, unfortunately, the PWD candidate turned out to be an SC candidate. So accordingly, he was adjusted against an SC quota. That's the grievance.
Lordship, on the other hand, on the writ petition, there is an order.
All right, he wants.
My lord will give him a week's time now.
Mr. K. Mohanto, learned counsel appearing for the, you have for the
Petitioner.
petitioner. Stroke OP in the IA number
798.
79. 798 of 2023. prays for and is granted 10 days time to file an objection opposing the prayer made in the IA. Mr. UK Nair, learned senior counsel, assisted by Mr. MP Sharma, is present on behalf of the applicant. Let this, in view of the prayer made by the learned counsel for the respondent OP, read petitioner OP, let these matters be listed again after 10 days.
That's one small prayer, Lordship. In the main petition, there's an order of this court, a direction given to the government advocates to furnish the information. Till now, they have not furnished. 5/1/2023
Meanwhile,
order.
the learned government advocate may obtain instruction as per the earlier order.
5/1/2023.
My lord, can I date any date convenient to your lordship after my lord 10 days?
Yes. Let these matters be listed again on 31st of May.
Lordship.
Oblige, Your Lordship.
Lordship, I'm praying for some time, Lordship, to file affidavit. Otherwise, it is with prepared and sent, Lordship.
While several
Yes.
time has been granted. And it is a case of premature retirement. The petitioner is suffering, my lord.
Premature retirement on date of birth.
And date of birth is correctly recorded, my lord. As per service books, he has not been retired, my lord.
Then we'll give him one last chance, 2 weeks time. Ms. P.
2 weeks.
Burman, learned counsel for the
A
petition.
date will be fixed.
Also heard Mr. B. Chaudhary, learned standing counsel,
Agriculture.
Agriculture Department, Assam, who prays for and is granted 2 weeks time and last chance to obtain affidavit, obtain instruction and file affidavit in the matter. Registry to list this case again on 2nd of June 2023 as a fixed item.
I fix it. Much of it. Item 30.
Along with item 29.
Well, as per the order dated 13/2/23, my lord, the director respondent was directed to file affidavit or else to remain present, my lord, on next date.
Lordship, in this case, Lordship, we are unable to file the affidavit because the situation is beyond our control, Lordship. The council who was handling this matter, the government council, Lordship, suddenly he has to be hospitalized. Thereafter, Lordship, it was prepared, it was kept in the file. And on 15th, Lordship, I think he's admitted at Bangalore. Therefrom, he rang up that this matter is there. Accordingly, Lordship, on 15th, we have written a letter to them to come on 15th of this month. So though that order is there, Lordship, I am praying for some more time, Lordship, because the situation is beyond our control, Lordship. The affidavit is here, Lordship. It is yet to be signed, Lordship. Because of that situation, he has to be hospitalized immediately. That is the situation. So may I pray, Lordship, at least 7 or 10 days time.
This court will consider direction.
Yes.
There is no direction.
Lordship.
Heard Mr. B. Borua, learned counsel for the petitioner, also heard Mr. H. Sharma, learned additional senior government advocate Assam, appearing in this on behalf of the respondents who submits that in terms of the order dated 13/2/2023, the affidavit has been prepared. But since the learned departmental counsel handling the big brief had to rush to Bangalore and was hospitalized on 15/5/2023.
No, Lordship, on 15, no, prior to that, on 15, he informed us.
And was hospitalized therein due to critical ailment. The affidavit could not be brought on record. Mr. Sharma therefore submits that since the failure to file affidavit was on account of circumstances beyond the control of the learned departmental counsel, 10 days further time be granted to bring the affidavit on record. Taking note of the ground on which the prayer is made, same stands allowed. Let this petition be listed again after 2 weeks. In the meantime, the affidavit be brought on record.
Much okay.
Item 31.
Lordship, in this case, the respondent authority has filed their affidavit. In the affidavit itself clearly reveals that, Lordship, though the termination order was issued on 5/8/2022, but the interim order was passed by the Honorable Court on 25/8/2022. That interim order was duly served to the Lordship respondent, and accordingly, as per the affidavit of the respondent authority, they have said that the maternity leave application of the petitioner has been considered on humanitarian ground. Lordship, they have considered. After the, after the lordship,
You want to file rejoinder or not?
yes, lordship.
Then why have you started?
Lordship, only my humble submission is that
Mr. Sharma,
since
I have
not been
noticed
terminated, lordship.
you
I may be
always
allowed.
behave like a client, behave like a lawyer. You are not the client here. You don't have personal interest in the matter.
Yes, lordship.
Yes, so behave
Only-
like a lawyer.
Yes,
Mr. D. Sharma, learned counsel for the petitioner and prays for and is granted 2 weeks time to obtain instruction and file rejoinder in response to the counter affidavit filed by the department. Mr. H. Sharma, learned additional senior government advocate Assam is present. In view of the request made by the petitioner's counsel, let this matter be listed again after 3 weeks.
Valuable.
Item 32.
May it please your lordship. Lordship, I have received instruction, my lord. Point 5 and 6 is relevant, my lord. Total arrears of Sri Pegu turn out to be 59,800, and we have written a letter to the revenue department for release of the fund.
Yes, so
We have also received instruction that is.
May please, instruction has been issued to pay the arrear sum of 59,800.
Yes, my lord.
So let them pay it, we'll give them 4 weeks time. After that, it will carry interest.
Now, your
Heard
lordship,
Mr. M. Talukdar, learned counsel for the petitioner. Also heard Miss M. D. Bora, learned government advocate.
I'm 4 and 6, my lord.
Appearing for respondent numbers 4 and 6, who has produced a copy of the written instruction dated 28/3/2023 to show that steps have already been taken for release of a sum of rupees 59,800 being the arrear dues found entitled found to be payable to the petitioner. First of Mr. S. Datta, learned standing counsel, the Revenue Department has also produced a copy of the written instruction dated 10/4/2023 to show that necessary steps for processing the release of payment to the petitioner has already been initiated at the departmental level. First up, in view of the above and taking note of the request made by learned counsel for both the sides, seeking 6 weeks further time to complete the process, this matter stands adjourned for 6 weeks. It is, however, made clear that if the payment is not released within 6 weeks from today, this court will consider levying interest on the unpaid dues of the petitioner till realization. Copies of the communication dated 28/3/2023 and 10/4/2023 be retained in the record of this case.
lordship, there is a question of the regularization of the service.
The prayer for regularization of service will be considered on the next date fixed.
Already rejected by this honorable court. This price has already been rejected by this honorable court.
Then
Regular
don't add
prayer.
this.
Yeah.
Yes, next matter. Don't add this. now. Yes,
May it please the lordship. Lordship, the petitioners before your lordship are aggrieved by non-payment of their grade,
non-payment of
non-payment of their grade pay, higher increase of grade pay, lordship. We are aggrieved by non-payment and higher increase of grade pay.
Instruction yet to receive, lordship. 2 weeks time required.
Lordship, if I may point out, page 59 in lordship. there is
So Mr. Monto, great pay affidavit will be required. Mr. K. Monto, learned counsel is present on behalf of the petitioner. Ms. S. Borua, learned government advocate Assam submits that the instructions as called for are still awaited and therefore 6 weeks further time has been paid for obtaining instruction and filing affidavit. Prayer allowed.
Fixed date,
Let this writ petition be listed again after 6 weeks. In the meantime, the respondents to positively file affidavit bringing their stand on record. Yes.
Oblige, your lordship.
Lordship, yeah, instructions have been received. Let me find an affidavit to bring on record the instruction.
Heard Mr. Alamgir, learned counsel for the petitioner. Also have Mr. C.S. Clerical, learned government advocate Assam, who submits that instructions have been received and therefore he be granted
2 weeks time to bring on.
2 weeks time to bring the same on record in the form of an affidavit. Prayer allowed. this matter be listed again after 3 weeks by tagging the affidavit of the department with the record of the case.
Obliged.
Main cases. Lord, we've been served with an affidavit on 16. We'd like to respond to that.
May I just pray for a fixed date, Manoj? My assisting councils are coming from Delhi. So
In my matter, in fact, the refinery has admitted the fault matter. They said the.
So 2 weeks, we'll post it after 2 weeks. Heard Mr. B.D. Dekal and council appearing for the. You right, heard Mr. Ken Chaudhary and the senior council appearing for the petitioners in, you'll see it in order dated 24/4/2023. So and so and Mr. So and so for so and so. Mr. Deka, 2 weeks time to file rejoinder, responding to the counter affidavit filed on behalf of.
IOC.
IOC. Mr. I. Chaudhary, London Senior Council listed by Ms.
Miss Tanishta Singh. Tanishta Singh.
As Mr. Singh is present on behalf of the IEC, accepting the prayer made by Mr. Deka. These matters are directed to be posted again on 5th of June. 5th of June.
okay.
My lord, could it be on 7th, my lord? 6th or 7th?
7th of June 2023, so as to enable the petitioners council to file rejoinder. The registry to list these cases again by tagging pleadings with the record of the case.
I has been filed, my lord, for recall or modification of the order dated 13/2/2023. Lordship will find it at page number 11.
Page number 11
Yes, madam.
of the IA.
I am.
Let us see the IA.
This one, private.
What is the modification?
By this order, my lord, the respondent 5 was debarred from filing an affidavit in opposition. I am seeking a leave, my lord, that I am, in fact, it is ready, I can file it today also. Subject
No,
to-
but when is the writ petition?
My lord,
When is the writ petition fixed?
the petition, it has been fixed today, my lord, along with this. It was listed on Wednesday. Just come up today.
Has it been listed today? Writ
Yes,
petition,
it will have to be along with the IM and comes with the IM.
we'll take up the writ petition and IA finally. Who is the council?
So, my lord, without the liberty, my lord, I will not be able to file the opinion in opposition.
Let's see if there is no necessity, we'll render it infectious.
Yes.
At 2, you argue on merit.
My lord.
For orders. I just modify.
Please, your lordship. In this case, honorable court's order, your lordship will find page 16, your lordship. Para 23.
So what has happened? This order has not been complied.
My lord, we have complied, my lord, his interpretation, my lord, blinded friend, my lord, petition interpretation,
No,
my
no.
lord. I'm submitting, my lord. My lord, this service, my lord, which was regularized, my lord. It was regularized, my lord, for pension, my lord, but that's his salary claim, my lord, area salary. My lord, he was not in service, my lord, only his service was regularized, my lord. Other part paid, my lord. We have filed affidavit also, my lord.
No, your lordship.
Last page 16, my lord, your lordship, the period from shall be regularized by the authority, consequently, this widow, so and so, and all consequential benefit due to late, so and so, all such.
So what are they seeking? The salary also?
Salary, my lord, that part, my lord, that part, my lord. That part.
For the period from 4/5/2000 to
My lord,
19/8/2004.
Yes,
for my lord.
yes, my
So
lord.
you have not given the salary.
My lord, the salary part, no, because he was he was not service, my lord, no, service was not, he was not in service.
And where is the order giving the other things?
My lord, we file affidavit, my lord.
Yes, where is it?
The affidavit, my lord, is page 49, my lord, this running page, my lord. 51, my lord, this 51, my lord, paragraph 4, my lord. Paragraph 5. The dependent paragraph 5, my lord.
All right, we'll close the matter. You will get the liberty to file a fresh writ petition on service. The service salary for the period has not been granted by the court in so many words. If you get an order, you can get it, otherwise it may not be available. Consequential benefits does not include salary for the period from so and so, so and so.
You lordship will kindly peruse the order. You
Yes, yes, I perused it.
order, my lord.
Yes,
May I read it?
yes.
Page from page 15, your lordship.
Mr. Chaudhary, I have seen it. I have seen the order. It is before me.
My lord.
On this order, you cannot hold up the authorities on contempt for non-payment of salary. There is no specific direction.
Well, see,
Heard Mr. RM Chaudhary.
para 23, your lordship.
You heard Mr. SK Mehdi, Learned CBC, Mehdi, Learned Council appearing for the respondents. This contempt case has been filed alleging willful disobedience of the order dated 03/12/2015 passed by the learned single judge in WPC number 5759/2010 containing the following directions. In page 16, you please quote the direction, para 23 and 24, full stop. In terms of the aforesaid order of this court, the respondent authorities have already disbursed an amount of rupees, have already released an amount of rupees. Where is the order releasing the amount?
My lord. Releasing amount. Releasing amount.
Mr. Mehdi,
Yes.
there is a affidavit. Where is it?
Yes, madam. Affidavit is there, madam.
Releasing an amount of rupees 10,27,915 as arrears of family pension. It A dibaho.
My lord, this, my lord,
Come on.
additional affidavit, my lord, file, my lord.
B.
14 August 2018, my lord.
Hmm.
Statement is given, my lord.
What else is it? 14 August. Take it, let him show me.
Your lordship will see my reply also. I have filed reply, your lordships. Page 26, para 6, your lordships.
Mr. Mehdi.
Yes, ma'am.
You have the world of time because you deal
No.
with one or two cases a day. We have a lots of things
Yes,
to
ma'am.
do.
Well, here,
Don't be so casual and leisure.
my lord, here, my lord, this amount, my lord, the period, it is defined.
Give me the affidavit. I'm only asking for that.
This 51, my lord. breakup service, my lord, this.
What is the total amount paid? There's no mention anywhere in the affidavit. What is the amount paid for what purpose? Nothing. You passed an order of 18th October 2019.
Yes, madam.
There it is mentioned. Is this correct figure or not?
I'll add to my lord, add to my lord, give me.
Area of family pension rupees so and so, 10,27,900. You will prepare the case after it is taken up in the court, is it?
No, my lord, actually, my lord.
Number two, death gratuity of rupees 1,09,231. Bracket after deducting the debit balance of rupees 20,821 bracket close. And number C, cost of rupees 25,000. Full stop. Notwithstanding the same, the petitioner is pursuing this contempt case on the ground that the respondents have not paid the salary for the period from
4/5/2000 to 19/8/2004.
4/5/2000 till 19/8/2004. Full stop. According to the petitioner, the expression consequential benefits would also include salary for the aforesaid period. Full stop. Mr. Medhi has however submitted that by following the principle of no work, no pay, the petitioner has not been paid salary. Full stop. In view of the above, it is apparent that the claim of the petitioner for payment of salary for the period from
All documents there, my lord. All documents is there.
who will go into all these things? You have to give him the
Yes,
figures.
yes.
For the period from so and so. Has to be adjudicated by the court on a proper petition filed by the petitioner. Full stop. However, there is no such direction in the order dated so and so passed by this court for payment of salary. On the order dated 3/12/2015 passed by this court for payment of salary to the petitioner for the aforesaid period. In view of the above, I close this contempt case by granting liberty to the petitioner to file appropriate read petition agitating her grievance in respect of the aforesaid issue, if so advised. I close when this contempt case is hereby closed by granting liberty to the petitioner to file a separate read petition agitating her grievance in the matter on the aforesaid count. Yes, item 46. Who is appearing?
This matter has already been admitted for hearing and
None appears for the petitioner. Ms. R. Devi, learned counsel for the respondent, submits that since the read petition has already been admitted, this matter be now posted for final hearing in usual course. They are allowed, list the case accordingly.
Lord. Lordship will find the order at Lord.
Heard Mr. P.K. Dekkal, learned counsel appearing for the petitioner, alleging willful disobedience of the judgment and order dated 27/9/2022 passed by this court in WPC number 6279/2018. This contempt case has been filed. I have perused the statements made in this petition. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within a week from today. So Ms. DP Sonowal and everything else, you just write the date and order. See, sole respondent. Yes, 8 months.
51 same matter, my lord.
Same.
Same 53 and 54 also, my lord.
53, 54 also said. I think these are all sole respondents. 54, you are appearing.
Yes, my lord.
You are not there in 54.
54, my lord.
All right.
Sorry, my lord, 53.
So 50 to 53 is not sole respondent. There are a number of respondents. Just check it once. Yes, item 54.
Order page 7.
Mr. H. Alamgir, and then this is sole respondent.
Item 56.
Yes.
May I please, Lordship?
You are arguing for disposal.
This was Lordship.
You want to start now? 30 seconds to conclude.
It will take time.
It did.
Lordship, you fix it some other day. As your convenience.
What do you say?
I have filed one affidavit, my lord. I
Lordship,
don't know.
it's already, I am under suspension for 10 months, Lordship. It's already too late,
If
Lordship.
both of you are ready, I'll take it up in a second.
I am ready, Lordship. I am
You
ready.
discuss among yourselves.
Lordship. At least
There is one item.
Hmm.
It will take some time.
14.
14. Regarding my learned friend is the petitioner. I am for the private respondent. Next week, Friday, my lord, second.
No, Mr. Chaudhary, don't do this. Not today, but on such and such.
Or-
Because we
or-
have lot of,
After
if you
two-
don't want to do it today, fine. But on a
Okay, in any
particular
case,
day,
18 matter automatically it will come.
yes. After 2 weeks on a
Yes.
non-miscellaneous day. What do you say? After 2 weeks?
But if your lordship fixes a date, my lord, that is the.
No,
After 2
that
weeks.
is the modus operandi. I will not do today, but I will do it on such and such day.
What
What happens is that prayer this court will not accept. I do it today then, because there is time, second half is entirely there. On the joint prayer of so and so, learned council.
After 2 weeks, my lord.
Let this, the admission hearing of these matters stand adjourned for the day. Let this writ petitions, how many writ petitions?
One.
Let this writ petition be listed again for admission hearing on a non-miscellaneous day after 2 weeks as a fixed.
Yes,
date.
yes.
May I please, Lordship?
In this case, I am appearing on behalf of Mr. S.S. Roy. He has left due to some personal difficulty.
Hmm.
So if any order is passed, I have no objection, but he is not here. He's.
So what is the order you want?
SC candidate, but in the order it was reflected as OBC candidate, OBC category. Lordship, kindly see page number 11.
Take down, heard Mr. R. Sharma, learned counsel for the applicant. Also heard Miss
S. Kakoti.
S. Kakoti, learned counsel appearing on behalf of Mr. S.S. Roy, learned CGC, appearing representing the respondents. Full stop. This IA has been filed with a prayer to correct a typographical error which has crept into the order dated 28/4/2023, passed by this court in WPC number 1644/2023. Mr. Sharma submits that the writ petitioner in WPC so and so is a candidate belonging to the
SC category.
SC category, but it has been erroneously reflected in the order that he belonged to OBC category. Full stop. The instant application has therefore been filed by seeking necessary correction of the order dated 28/4/2023. First up, Ms. Kakati, learned counsel appearing for the opposite party submits under instruction that she would have no objection if the prayer made in the IA is allowed by this court. In view of the above, and after going through the materials on record, this court is of the view that the prayer made in the IA deserves to be allowed. As such, it is hereby provided that the petitioner in WPC number 1644/2023 shall be treated as a candidate belonging to the SC candidate for the purpose of benefits to be given to him under the order dated 28/4/2023 passed by this court, with the above clarification / correction in the order dated 28/4/2023 passed in WPC number 1644/2023. This IA stands disposed of.
It's at 2 PM, item 24.
My lord, I received instruction today, my lord. I have instruction and a pair of comments, my lord. This matter may be fixed on 29th. Next week I will have.
Yes. Heard Mr. Arvind, learned counsel for the petitioner, also heard Mr. A.K. Datta, learned CGC appearing for the respondents who submits that he has recently received instructions as well as pair-wise comments and therefore be granted time till 26th May 2023 to bring the same on record in the form of an affidavit. And since the prayer is not opposed, same stands allowed. On the request of the learned CGC, let this matter be listed again on 31/5/2023 as a fixed item by taking the affidavit, if any, filed by the.
My lord, let it be
respondents.
on first week of June. On 31st, I have some difficulty.
So second of June.
Much.
So by tagging the affidavit, if any, filed by the respondents, the petitioner may also find rejoinder in the meantime, if so advised.
No, obligation.
Item 59.
Yes, modification of which order?
My lord, this I application has been filed by my lord, respondent number 5, my lord. Give me 5 minutes, sir.
I filed the IML.
For modification. of order, my lord,
Page 11,
page
my lord.
10, my lord.
11. The relevant part, my lord.
I.
Page number 11, my lord, the relevant part of the order.
No, why the affidavit could not be filed earlier?
My lord. Well, there was some miscommunication, my lord, with the council, my lord, that has been stated. And
Where is the statement? Let us see.
yes, my lord, paragraph 3, paragraph 3, my lord. Three and 4.
Heard Mr. B. Gogoi, learned counsel appearing for the applicant, also heard Mr. B. K. Das, learned counsel representing the OP stroke read petitioner. Mr. A. Chakravarti, learned government advocate Assam, has appeared for the official respondents. This IA, arising out of WPC number 2549/2020, has been filed by the respondent number 5 stroke applicant. Respondent number 5 in the read petition with a prayer to modify the order dated 13/2/2023 passed by this court in WPC number 2549/2022, striking of the right of the respondent number 5 to file affidavit beyond on the expiry of the due to failure on her part to bring the same on record within the time permitted by this court. By referring to paragraphs 3 and 4 of the application, Mr. Gogoi submits that the delay in filing the affidavit was due to reasons beyond the control of the applicant. First up, contending that the affidavit has already been filed. Mr. Gogoi submits that if the same is not taken on record, you already filed it.
No, madam. Without leave of the court, I cannot file. But it's ready. I can file it today itself. Madam.
Mr. Gogoi submits that the affidavit is ready and shall be brought on record during the course of this day. The learned counsel seeks leave to file the affidavit by modifying the order dated 13/2/2023. First up. It is also the submission of the applicant's counsel that if the affidavit is not taken on record, affidavit of the respondent number 5 is not taken on record, the same may lead to miscarriage of justice. First up, the learned counsel for the read petitioner, as well as the learned government advocate Assam, has not controverted the stand of the counsel for the applicant. In view of the above and considering the grounds stated in the IA, the prayer stands allowed. The applicant stroke respond number 5 is permitted to file the affidavit during the course of the day. File the affidavit in WPC number 2549/2020 during the course of the day. If such affidavit is filed during the course of the day, the same be taken on record. To the above extent, the order dated so and so, 13/2/2023. Passed in WPC number 2549/2020 stands modified. IS stands displayed.
Obliged. Obliged. And Malud, the writ petition will come up after 2 weeks, Malud, or 10 days,
The
Malud.
writ petition will be listed after 10 days.
Obliged.
The last item.
May I please, Lordship?
Yes.
Lordship, before coming to the main issue of suspension, if your Lordship kindly allow me to give the little background of the case, Lordship, for the better.
Which order you are
understanding.
challenging?
Lordship, kindly come to page, Lordship. Page 33, Lordship.
Page 33.
Page 33, Lordship.
Yes, please read the order.
Here is the proposal of suspension, revoke of from service of MMR and Qazi, namely Azhar Ali and Mohammad Yunus Ali Ahmed, submitted by the Additional Deputy Commissioner Salma Mankasar, by letter number so and so, dated so and so. Whereas it is observed that Mohammad Azhar Ali, MMR and Qazi Shuksar Police Station area have violated Rule 5, Rule 12D and Rule 53 of Assam Muslim Marriage and Divorce Registration Rule 1935. By violating jurisdiction, leaving headquarters without permission of the concerned authority, and not submitting copies of registration marriage as well as monthly return to the district register. As such, in exercising power delegated under Rule 8 of Assam Muslim Marriage and Divorce Registration Rule 1945 and Rule 2 of Qazis Act 1880, and pending drawal of disciplinary proceeding against Mohammad Azhar Ali, MMR and Qazi of Shuksar Police Station area in Salma Mankasar district is hereby placed under suspension with immediate effect for gross insubordination and indiscipline in complying order of district register Salma Mankasar issued and failing to receive and show cause notice issued by so and so. Here, Lordship. My humble submission before your Lordship.
Submission will come later. First, what is the case? What is the ground?
Ground, Lordship, here I am placed under suspension pending drawal of disciplinary proceeding. But the respondent authority completed a disciplinary proceeding against me, and that is why I am temporarily withdraw from my service so that a fair inquiry can be conducted. That is the motive. And pending drawal of disciplinary proceeding, I am placed under suspension. Lordship, there is no such provision of disciplinary proceeding against a Qazi or MMR Muslim register in the relevant law, Lordship. And next, Lordship. Lordship, I would like to take a Lordship page 38, show cause notice, Lordship. Because notice, Lordship, issued to me, it was not served upon me. I am to inform you that you had been asked to appear before me on so-and-so for discussion and functioning of MMR and Qazi and various issues relating to Muslim marriage registration and role of Qazi. But you have failed to appear before me in stipulated time and date against when inquired it. When inquired it was later found that you have been absent from the district for last 4 or 5 days without taking prior permission from Deputy Commissioner, who is also District Register Salma Mankasar. Hence, you are ordered to submit reply to show cause as to why disciplinary action should not be initiated against you for this subordination and be present before the undersigned on so and so without failure. Here, Lordship, is focus notice, Lordship. I was earlier asked to appear before the respondent authority in a meeting to discuss the role of Qazis. And subsequently, the respondent authority found that I was absent. And I was absent due to some medical reason. That was over telephone, I intimated to the office of the respondent authority. And later on, what they found that I was absent for 4 or 5 days. That is why the show cause notice was issued. Lordship, may kindly come to page 39, the inquiry report, Lordship. After that show cause notice that was issued, I was absent, that was not served upon me, and inquiry was conducted. And the inquiry officer, Lordship, asked me to appear before the inquiry officer, and that too without supplying me, without furnishing me any materials, any documents on which they are going to rely upon, the materials which they are going to read against me during the time of inquiry. Nothing was furnished to me. Still, I appeared before the inquiry officer, Lordship, kindly page 40, Lordship. May I read, Lordship? With reference to the subjects cited above, I have the honor to submit herewith the inquiry report on suspension of Muhammad Azhar Ali Ahmed, Imam Qazi of Shuksar Police Station, and Muhammad Yunus Ali Ahmed, Imam Qazi of Mankasar Police Station, excluding Kalapani OP, as follows. Inquiry conducted for Muhammad Azhar Ali, that is myself, Lordship. During inquiry, Muhammad Azhar Ali Ahmed, Imam Qazi Shuksar PS area has submitted the documents which are found in the year 2020. He has produced only registration form, but could not produce any other relevant documents. During inquiry, he could not produce his official seal, rubber stamp, etc. as per his new jurisdiction area. He has still working the old official seal, rubber stamp in his earlier jurisdiction area, violating the official order of IGR and Govt of Assam. During inquiry, it is found that Muhammad Azhar Ali Ahmed had lack of knowledge about his official duty and Muslim marriage registration and role of Qazi. He has also mentioned that he is quite old now and difficult for him to serve his duty. And during inquiry, he has denied to submit any statement. He has submitted only attendance in presence of his engaged advocate. Here, Lordship, nothing has been there which has been mentioned, which has been alleged in the show cause notice. In the show cause notice, I was absent for 4 or 5 days, but that is not there in their inquiry report. So inquiry report, Lordship, has been conducted in different line altogether, Lordship. What is what allegation made in the show cause notice, Lordship? That is totally different in the inquiry report. In show cause notice, I was absent for 4 or 5 days unauthorizedly. That is their main contention. But in the inquiry report, what they have found, they have that Lordship, there is not a single whisper not a single whisper against regarding my absence, Lordship. And Lordship, may kindly come to page, Lordship. Hmm. 35, Lordship. This is the public complaint, Lordship, which they alleged to have initiated action against me on the basis of this public complaint, Lordship. This is the public complaint, Lordship, long complaint, Lordship. And here, Lordship, 3 MMR Qazis. One Muhammad Azhar Ali, myself, another Muhammad Yunus Ali, another one, and Abdul Kalam, another one. 3 MMR Qazi have been working under Sasuma Mankasar district, Lordship. Against all of them, there is a public complaint filed by public, whoever may be, Lordship. But is there any inquiry, any preliminary inquiry conducted by the respondent authority that I am convicted or I am involved in the allegation made by this complaint, or Abul Kalam Azad, Muhammad Yunus Ali? In record, there is nothing, Lordship. Here, Lordship, on what basis respondent authority only placed me under suspension, and they have absolved totally Abul Kalam and Muhammad Yunus Ali. On what basis? complainer, they are against all the cases, but only they have taken action against me. And Abul Kalam, there is no sin of Abul Kalam. Yunus Ali also, they have also initially although they have taken action, but subsequently he is also absolved from the allegation, Lordship. This is the arbitrary and malafide action taken by the respondent authority, Lordship. There is no basis that only this complaint is they are against all the three cases, but action is against me, Lordship. Here, Lordship, I'd like to take your Lordship page 18, Lordship. Kindly. Lordship, this is the order passed by this honorable court, Lordship, because I am a MMR Kazi, have been working under Sasoma Mankasar district since 1997. During long 25 years of my service as an MMR Kazi, there have been no complaint, no objection, no issue of suspension at all during this entire period of my service, Lordship. So what happened, Lordship? The respondent authority illegally appointed one Abul Kalam in my jurisdiction, which is hit by Section 3 of the Muslim Marriage and Divorce Registration Act 1935, Lordship. And that is why, Lordship, this honorable court, when I challenged that appointment, which was given in my jurisdiction, because no two Qazi can be appointed in same jurisdiction, Lordship. Still, they have, on some extraneous consideration, the respondent authority appointed one.
This suspension is for eternity.
Lordship.
Order of suspension of licenses for how long?
My lord, there is no specific kind of period, my lord. That some inquiry is going, my lord, as because, my lord, that MMR and Kaji, they are not, my lord, they are government servant. They are like, my lord, the Gavuras.
Then how departmental disciplinary?
My lord, discipline proceeding, my lord, regarding, my lord, that the inquiry is going on, but the inquiry is done by the deputy commissioner. Whether the, my lord, he has that, my lord, the complaint was received, my lord. And as per the, my lord, that
No, what he is saying is 3 complaints received against 3 Kajis.
Three cases, and two, my lord, their complaint is given 3 cases. My lord, that as per the inquiry, my lord, only 2 cases they have been found. My lord, there's an inquiry report already been, my lord, my learned friend has been, my lord, said as per the page 41, lordships. One is my lord, Azhar Ali and another is Yunus.
So only Azhar Ali has been suspended.
Suspended. And my lord, that Yunus Ali, my lord, he has committed some mistake, my lord, he was, my lord, regretted, and my lord, he said that he was absent from the duty, my lord, that the duties, my lord, without the permission. As per the, my lord,
Ask the deputy commissioner to review the order.
my lord, that deputy commissioner, all the inquiry is made, and my lord, that concession, my lord, is going on. My lord, the inquiry is going on, my lord. My learned friend can say, my lord, what is the, my lord, stage is, my lord, is.
May I please, Lordship? Your Lordships may kindly come to page 39, read petition. This is a report by the Deputy Commissioner come District Registrar Charles Salmana Mankatra to the Inspector General of Registration. With reference to the subject cited above, I have the honor to submit here with the inquiry report on the matter of insubordination and indiscipline of Muhammad Azhar Ali MMR Kaji so and Muhammad Yunus Ali so. And on the perusal of suspension, revoke some so lordship. Now, next page, this is the inquiry report. The first page 40, inquiry
What action
conducted
has been taken on the inquiry report?
on the basis of the preliminary inquiry report. Now, lordship, we have appointed inquiry officer and presenting officer, and accordingly, the notices were issued to him to appear before the inquiry officer, which he refused. Accordingly, lordship, the Lotkazari was there. It was hung in his wall.
Where is the notice of inquiry proceeding?
Lordship, though we have not filed our affidavit, lordship, we have received the instructions. Hide the order dated 3rd of April 2023, inquiry officer as well as presenting officers were appointed. And accordingly,
what is the stage of the inquiry?
Stage, lordship, it was fixed on lastly as because earlier it was fixed on 12th 12th of April. He refused to accept that notice. Accordingly, it was again deferred to 26/4/2023. Lotkazari was there. On 26th, thereafter, Lordship, we have. So he refused to appear in the inquiry.
We'll ask them to conclude the inquiry.
Yes, Lordship, let him appear.
Lordship,
The order cannot be interfered with.
Lordship, as because
There is
the
an
inquiry is already.
going on.
no, Lordship, inquiry report, final inquiry report has already been submitted by the,
No,
inquiry-
Lordship.
by the inquiry officer, recommending to cancel my license, Lordship. The page 40, Lordship. And after the last order passed by.
No, no,
That was the
Mr.
preliminary order, preliminary inquiry.
See, please understand, this is a writ proceeding.
Lordship,
We are not going to go into the merit of the order.
Lordship, Lordship,
We'll only see whether the process is correct or not.
exactly.
They are saying you have not appeared after the receipt of notice. They are finding it difficult to catch hold of you. These are circumstances where writ court will not come to your rescue. If
Lo-
he is saying the inquiry is going on, if you dispute it, we'll ask him to file affidavit.
Lordship,
Are you disputing that the inquiry is going on?
the inquiry is going on, Lordship.
Then you
I'm not
appear,
disputing.
you appear there.
I am not disputing, Lordship. I furnished my reply with regard to that.
right,
That is
that
preliminary,
Lordship.
preliminary,
No, now a regular inquiry is going on.
going on.
That is what he is submitting. You appear there, we'll ask them to conclude it
Lordship.
in a time bound
Lordship,
manner.
according to the last order passed by this honorable court, Lordship, the court has clearly said that there can be no departmental proceeding, Lordship. And they're serving me notice that we are going to draw a disciplinary proceeding, departmental proceeding against you, so you appear before.
So you
Lordship.
mean to say your client can do whatever he feels like, there is no one who can say anything to him?
Lordship, that is not, Lordship.
Then
I am ready to appear, Lordship. I am ready to appear.
you appear,
I'm ready to appear.
cooperate, let it be concluded, then we'll see if they act in an arbitrary manner.
Lordship, Lordship.
It is for your conduct, things have been delayed. You should have appeared. You can't take on the administration like this.
I am not.
Then you appear, we'll ask them to conclude the,
Earlier occasion also I appeared.
but within how long can you conclude the inquiry?
If we appear, Lordship, within 2 or 3 months, Lordship, we can surely complete
All
it.
right, within 60 days you can. conclude
Lordship,
it. And then,
let him appear, otherwise we will proceed expertly, Lordship.
and on the basis of the inquiry report, this order will be reviewed by the
Lordship,
deputy commissioner
yeah, Lordship, Lordship,
within the outer limit of 90 days.
Lordship.
That's it. If you are aggrieved, then only we can
Yes,
go into
Lordship.
it. These
If
are
he is
all
found guilty, Lordship, he will be dismissed, or otherwise, Lordship, he will be reinstated.
License will be.
Yes,
There are allegations against your client. We can't say whether these allegations are right.
Maybe, Lordship, there may be allegation,
then-
but
then-
I have, as an principle of natural justice, Lordship, what they are going to do, the inquiry, Lordship, they should have furnished the documents and particulars which they are going to rely upon. I was not furnished with supply to any documents, Lordship. What I have furnished here, Lordship, I have got that documents.
So
and-
we'll ask them to furnish you with the, what is the allegation, what is the charge against you, and what documents are. We'll ask them to furnish it to you within 2 weeks from today.
Lordship,
Thereafter, you file your reply with.
reply, Lordship, so that I can make.
And thereafter, within 60 days, they will conclude the inquiry. There is no other way out.
Lordship,
That's the only way out. Nothing else.
Lordship,
can
I
be done.
had to assist the court, Lordship. My only humble submission, I am already 10 months, Lordship. My livelihood depends upon the fees I get from the registration, Lordship, frankly to speak, Lordship. Since 10 months, Lordship, I am out of earning livelihood and my big family is starving, Lordship. So if Lordship decides, Lordship, I am obliged to follow that Lordship's direction. So, Lordship, time may be given, short time may be given.
How much time you suggest?
30 days, Lordship, because already 10 months, Lordship. they are-
Day-to-day basis.
Day-to-day basis, Lordship.
if, had he appeared on 12th of April,
No,
by
that's
this
all
time
right,
it
that
should have
is
been
now gone.
completed.
That is now gone.
Let it be a 60 days, Lordship, thereafter within 30 days, let the
45 days.
Lordship. Then next page the notice, next page Lordship, Lotkazari,
No, now he will appear.
Lordship,
Within 7 days, he'll appear.
Lordship.
And in next 7 days, you furnish him the charge memo along with the documents and list of witnesses whom you want to rely upon.
Lordship.
Give him another 1 week to submit his representation. And thereafter conclude the inquiry proceeding and submit a report within 45 days.
Lordship,
In the light of the inquiry report, the order will be reviewed.
Lordship,
If he continues to remain aggrieved, he'll be at liberty to approach the.
Lordship.
That is the only order that can be passed.
Lordship.
Take down, heard Mr. A. Islam, Learned Counsel appearing for the petitioner. Also heard Mr. H. Sharma, learned additional senior government advocate Assam, appearing for the respond numbers.
Respond number 3.
Open
No,
to
six,
J and the learned SC Revenue Department Assam, for respond numbers 1 and 2. And Mr. H. Sharma, learned additional senior government advocate Assam, appearing for respond number 6.
Respond number 6.
The remaining respondents have not appeared. The petitioner hearing was appointed as a Muslim marriage registrar and Qazi, bracket MMR and Qazi, in the district of South Salmara 25 years back, and since then he has been functioning as an MMR. Full stop. In the year 1997, the petitioner was granted a license to perform the work of MMR in terms of the provisions contained in the Assam Muslim Marriage and Divorce Registration Act, 1935, and the rules framed thereunder. Full stop. According to the petitioner, he has been functioning as an MMR without any
MMR and Qazi.
without any blemish to his reputation. However, acting on some frivolous complaint received from persons with vested interest, the license, the license granted to the petitioner was suspended by the respond number 2 by order dated 16/7/2022. According to the petitioner's counsel, 16/7/2022, pending drawal of disciplinary proceeding against him. According to the petitioner's counsel, his client is not a regular government servant, and therefore there is no provision in the rule for drawal of disciplinary proceeding against the petitioner. It is also the submission of Mr. Islam that that after the issuance of the impugn order dated 16/7/2022, the petitioner has been out of work, as a result of which not only himself but his family members, consisting of minor children, are suffering immensely. On such ground, the petitioner's counsel has prayed for setting aside the order dated 16/7/2022. Controverting the stand of the petitioner's counsel, the learned departmental counsel have pointed out, have invited the attention of this court to the documents on record to show that the petitioner did not appear before the authorities pursuant to notice dated 26 May 2022.
Prior to that, 12/4 is also there.
12/4/2022 and 26 5/2022.
26/4.
26/5.
4. Today is 19/5. 26.
No, notice was issued on 26/5/2022.
Oh, Lordship. I'm sorry, Lordship.
26, FIS, 26/5/2022. As a result of which the preliminary inquiry had to be conducted in his absence. Thereafter, a report was also submitted before the respond number 2. Finding that the petitioner, projecting that the allegations brought against the petitioner were correct. Taking note of such preliminary inquiry report, the respond number 2 has ordered a regular inquiry, and accordingly, Sri Boni Inam Sabab, ACS, additional Deputy Commissioner, South Salmara Mankachar, and Sri Bolin Baba Balari, ALRS, Circle Officer, South Salmara Revenue Circle, have been appointed as inquiry officer and presenting officer respectively. Mr. Sharma, however, submits that since the petitioner has failed to appear before the inquiry officer, despite issuance of notice, the inquiry- Huh?
Which he refused to accept.
Despite issuance of notice which he refused to accept, there has been delay in conclusion of the inquiry proceeding. Mr. Islam has not been able to convince this court that his client has been cooperating with the inquiry proceeding. Full stop. Therefore, although the petitioner's counsel has submitted that no memorandum of charge accompanied by the documents and the list of witnesses which the department wishes to rely upon to prove the charge has been served upon his client. Since the petitioner has refused to respond to the notice issued by the inquiry officer, the said aspect of the matter, in the opinion of this court, cannot be gone into at this stage. Full stop. The petitioner, it is the undisputed position of fact that the petitioner is holding a license issued to him under the provisions of the Muslim Divorce, etc. Act. And therefore, if there are complaints received by the authorities against the petitioner, it cannot be said that the administration would not have any right to inquire into those allegations. Full stop. However, the inquiry proceeding undoubtedly has to be in accordance with the rules and definitely in consonance with the and definitely in observance of the principles of natural justice. Full stop. During the pendency of an inquiry, this court cannot, therefore, during the pendency of an inquiry wherein allegations brought against the petitioners are being looked into, this court cannot interfere with the order of suspension of license, more so when the petitioner has apparently failed to cooperate in the investigation, in the inquiry, not investigation, in the inquiry. As such, without expressing any merit on the, any opinion on the merit of the claims and counterclaims, insofar as the correctness of the allegations are concerned, this writ petition is being disposed of with the consent of learned counsel for both the sides, with the following observations. Number one, within 1 week from today, the petitioner will appear before the inquiry officer and produce a certified copy of this order. Full stop. Within 1 week from the appearance of the petitioner, he shall be furnished with a copy of the memorandum of charge, the list of documents and witnesses which the department proposes to rely upon in the inquiry proceeding. Full stop. Next, C. Within 7 days thereafter, the petitioner will file his reply to the charges. Full stop. Within 45 days from the date of receipt of the reply furnished by the petitioner, the inquiry proceeding will be concluded by right like this. In view of the delay that has already happened in this case, an attempt be made to conclude the inquiry proceeding as expeditiously as possible, but not later than 45 days from the date of receipt of the reply submitted by the petitioner responding to the charge brought against him. Full stop. Once the inquiry proceeding is concluded and a report is submitted, the respondent numbers 2 and 6 shall suitably review the order dated 16/7/2022, and if it is found that the allegations brought against the petitioner could not be substantiated, then they would forthwith withdraw the suspension of the license of the petitioner to operate as MMR and Qazi. and notify the same to formal communication. With the above observation, now then you write, if the petitioner continues to remain aggrieved in the matter even thereafter, it will be open for him to approach this court once again by filing a fresh writ petition. With the above observation, these writ
Lordship,
petitions can.
small query, Lordship. The review matter, Lordship, time may be given, Lordship, the review matter, Lordship. After conclusion of inquiry, the review may be completed within such and such.
Within another 10 days, after submission of review, within another
Yes.
10 days.
Obliged, I am obliged.
Lordship, I appear back on respond number 1, 2, 3, and 4. Lordship.
So Mr. Hendrick for respondent 1, 2, 3, and 4, and Mr.
I am
Sharma
for 6, Lordship.
Number 6. Remaining respondents have remained absent. That's all?
I am obliged.
Much obliged. Lordship.
That's all? Anybody wants to do a part 2 hearing matter on a Friday afternoon? Monday also?
Lordship.
All right, we'll finish up everything in motion stage now. No hearing, no admission, nobody is interested. Yes.